Welcome to the docket. I'm your host, Bob Mata, and this is my beautiful, brilliant proof that any man can outkick his coverage. My beautiful co-host, Ali. What's up, girl?
Hey, babe. Hi, all.
Hey, pull your mic
by
a
the
little closer to
way,
you
oh,
so
is
you
that
don't have to
better?
lean in. So you're comfy.
I was
want
just
you to
gonna
be
say how
snugly.
sexy you were, so it's all right.
Oh, please. You look gorgeous. I miss you. I'm glad that I was able to coerce you into joining me tonight. Big day in the case that never sleeps. Ton of filings. Now I was working all day with Jay. We were streaming James Crumbley trial, and early on, I became aware that Andy Baldwin had filed a little something, motion to compel and a request for sanctions, which we'll definitely be going through. And then I was trying to read that through the course of the day. It's lengthy. We'll obviously be going through that tonight. And then the lead pipe himself laid
What
some
does that
pipe
reference
today.
mean?
That means that David Hennessy is a lead pipe carrying motherfucker. And
Okay.
he knocks
He's
people out.
gonna F you up. All right, I got you.
I mean, he's that guy, he's a legend. So, and he came late to the game today with some filings. Dizzy is in the process of getting those all to me. Probably like an extra half an hour for me to decompress would have been good. It was a long day streaming with Jay, but that's an important case out there in Michigan with that Crumbley case. I don't know if people are sleeping on that, but
Maybe they feel like they kind of like got it from the mom. Is it very different?
It's different, it's different in the sense that they both had, very different relationships with Ethan. I think it's safe to say that Ethan's relationship with his mother was more conversational. I think that he communicated with her more than he did with his dad, which I don't think is atypical. But the question, as it's involuntary, and I'm not going to go on too long about this, but y'all should be joining us tomorrow. We believe the state is rested. I believe the only witness, if Crumbley is going to testify, will be Crumbley. And then it's going to closings. And if y'all don't understand the significance that case is going to have on Americans and parents in particular, wake up, because it's going to have a massive impact on how prosecutors and law enforcement look at parents of children who commit horrific acts of violence. And from now on, we're on the hook. If you're ignoring your kids and they go out and do unspeakable shit, you're going to have a problem. And I'll leave it at that. So you guys should check it out. Jay and I will be streaming that again tomorrow morning. So a couple of things before we jump in, babe. And just, I'm forewarning y'all, like I said, Allie's been working on a post-conviction relief act petition. I'd say she's at the goal line. She's probably more at like the 7-yard line, driving towards the end zone.
It's got to get filed before 8 a.m. tomorrow.
14th, right? Yeah. I mean, so she's up against it. Today is the 12th, I think. Yeah. So you got a couple days. You got a little extra respite there. But I want to address. So I am dealing strictly with filings of consequence, meaning that I will not be addressing anything that was filed by YouTubers
Well, no, I
yesterday.
mean, you don't
Uh,
say right, just I mean, we're
just
not it
let me
happened
get
to be
this
those
out.
ones yesterday. Okay, sorry.
Well, they were the only ones filed yesterday. But and I'm gonna just say this for two reasons. I'm not going to cover them. One, because they are of no legal consequence whatsoever. Uh, Nick McClelland, in my opinion, if you care about justice for the girls, Nick McClelland wasting his time on this particular motion that's going to be heard on the 18th instead of preparing for a case that is 62 days away is making a grave mistake. And that's just my opinion. You know, if you care about justice for the girls and you're of the opinion that Rick Allen's the guy, you should want your prosecuting attorney focusing on the case at hand, not some collateral issue that we've all heard about.
And that
To
he can
me, this
address
is what
afterwards. It's not going anywhere.
it's not going anywhere. Exactly. Wait, table it, deal with it after the trial. You know, I mean, I just don't see what the goal is for him. Like, is he hoping they're going to get booted? I can't see that happening in any world, to be honest with you. As much as Gull might want to, I think that when the 70-day was filed, that she's hamstrung by that. This thing is going. This is a freight train that is barreling towards trial that will not be stopped until a jury is impaneled and this
And
case
just
is
so
tried.
sorry, babe, I was just gonna say, just so, people know, like, 2 months in, like, the legal world, like, the courtroom world is it's almost like 2 days or 2 weeks. I mean, it's like everything's kinda done on a month-to-month basis, so it's really, really fast.
Well, especially if you are
Focusing on
preparing for
another
trial. No, I'm like preparing for trial. You know what I'm saying? This isn't just like I'm waking up to go to court on a status hearing. This is
well, yeah.
preparing for the biggest trial of Nick McClelland's life by a million miles in a trial in which he's never dealt with anything even remotely close to this, as far as I know. And what he's choosing to spend his time on right now, his valuable time, is this bullshit. And I got news for him. David Hennessy has got this thing under control. Like Brad and Andy, you know what they're able to focus on? The trial, because Dave Hennessy is taking care of this. Dave Hennessy has this under control. So they're not having to waste time on this because it's collateral. It doesn't matter. It just doesn't matter. And the second reason that I'm not addressing any of those filings yesterday is because I don't care at
Mm.
all. So there's that.
Alright, let's
All
get
right.
to it.
So let's dive in. All right. So the first thing I'm going to deal with before I get into David's filings, we'll do Andy's. I consider it to be a bombshell. I really do. You know, like the one thing, love or hate Andy and Brad, they come with receipts and you know, they leave us not wondering anything. We know exactly what they're missing. We know exactly what they've been asking for. We know exactly the process that they've gone through. Like they just don't leave us wanting in terms of information. We're going to get it all, and it's something. And you know, I've got long thoughts on it, obviously. But let's get right to it. Motion to compel and request sanctions comes now the accused Richard Allen by through counsel Andrew Baldwin and Bradley Rosie and moves this court to compel the state of Indiana to provide certain discovery that the defense believes exists, but that the state of Indiana has not provided to the defense. Additionally, the defense seeks a sanction against the state of Indiana for a variety of discovery violations detailed herein. The sanction request is simple: that any delay in trial created by the state's violation of the rules of discovery be assessed against the state of Indiana. In support of said motion, the accused states the following. Now, before we jump into that, Allie, explain how the clock runs on a speedy and explain what they're asking to everybody in terms of asking that the time be charged against the state as opposed to against the defense.
Right. So they don't want it to be perceived as, and I don't think that they should, as stopping the clock, stalling the time. They want the clock to continue running. Um, and I guess when you'd say against the state, it just means the 70 days is the 70 days, or the 60 whatever left is the 60 whatever left. So
Right.
if something they do, causes a delay, I mean, I don't know how that would work, but because
With
it's not
respect to
like,
what?
well, because like when we are usually doing it, it's like you've got 120 days, whatever, and so I take 5 that, you know, the clock didn't run on those. They take 5, the clock ran on it. You're talking about 70 days. So
62. That's where we're
right,
at. 62
62
days
left.
until trial. May 13th is the big day. All right. So essentially what they're asking is that the time not count against them, meaning that no time can be added, that trial date can't be pushed beyond the 70 days because of delay by the defense. All right. All right. So let's start going through it. It's 18 pages. And like I said, they're coming with the receipt. They're coming with the details. All right, so paragraph 1, the defense has attempted to cooperate with the state of Indiana in order to comply with the spirit of local rule 08CR00-18, which is attached and marked as exhibit A for the sole purpose of assisting the court and supplementing this motion to compel. Paragraph 2, pursuant to local rule, the state of Indiana shall disclose and furnish all relevant items and information under the rule to the defendant within 30 days from the date of the appearance, subject to constitutional limitations and other limitations, and the defense shall provide the same within 30 days of the state providing its evidence. Pursuant to said local rule, the party seeking disclosure of evidence shall include in the party's motion or request a statement showing that the attorney made the motion or request, has made a reasonable effort to reach agreement with opposing counsel concerning matters set forth in the motion or request, including the date, the time, the place, and the manner that this effort to reach an agreement took place. To this day, the state of Indiana continues to provide late discovery of items of and information that it was required to provide no later than December 14th of 2022, pursuant to local rule. For example, and this is paragraph 5, on February 20th, 2024, the defense sent a certified letter to the prosecutor's office seeking many pieces of evidence, in parentheticals over 20, that the defense believes exists, but appears that the state of Indiana has failed to turn over to the defense. Paragraph 6, in that certified letter, the defense requested a determination if said evidence exists, and if so, to determine if that evidence has been turned over to the defense, as the defense was unable to locate any of the aforementioned evidence in the vast amount of discovery provided by the state of Indiana. In other words, the defense was seeking clarity as to whether the prosecution had turned over certain evidence or whether said evidence even exists. It's fair. It's fair. And this goes to what I was talking about the other day when these guys had to get reacclimated and they got the discovery back from the state. This isn't like they're just jumping right back in where they left off. This is, they've got to go through everything again, all of it, every stitch of it, every single document, in order to, number one, make sure that what they had before is still there. And number two, to make sure that they didn't stick anything in that they didn't know was there before. And number three, to make sure that anything that was there before is now missing. So all three of those things have to happen. All right. So they had to start from scratch. Okay. All right. Paragraph 7. The state of Indiana did not respond to the letter, but rather sent one e-discovery strand, which contained a small portion of that evidence that was requested, including certain videotaped interviews that have never been turned over, involving people that are integral to the timeline. 8, the state of Indiana turned over these pieces of evidence more than 14 months late, pursuant to local rule, without explanation.
Wait, I'm
Pursuant to
sorry. Are
local,
those the recordings that they were asking for before that were deleted or something? completely different,
I
or
mean,
we don't know
I,
yet?
I have no, I have no idea. Like, I mean, it could be. I have no clue. I don't think so, but it could be. I mean, all I know is that they're saying that they're 14 months late, which means that McClelland had them at the onset and his slow played discovery in terms of turning it over to the tune of 14 months late in a trial that is now 62 days away from being tried. Pursuant to local rule, paragraph 9, the defense is not required to make specific requests for any evidence. Parentheticals, as the state of Indiana is required to turn over all relevant items. And parenthetical, yet without making the specific request, it appears that the defense would have never received these most recent pieces of evidence, parenthetical, i.e. the videotaped interview of certain witnesses, and parenthetical, paragraph 10, the frustration from the defense is that this is not the first time that the defense has failed, that the defense has had to make specific requests for specific evidence that the state has failed to turn over to the defense. Because law enforcement and the prosecution are in total control, and I love this paragraph. This paragraph breaks down the frustration of every defense attorney on the planet and explains exactly the power of the state and the inability of the defense to know what they can't know in terms of what they have. You know, the prosecutor works hand in hand with law enforcement. The prosecutor gets what the prosecution gets from law enforcement, and until such time that the prosecutor goes through the documentation and turns it over to the defense has no idea what they receive from law enforcement, and frankly never will. There's a huge element of acting in good faith that comes along with the practice of criminal law for both sides, but in particular from the prosecutor's office, because they are receiving the discovery from law enforcement, and it's expected that they're going to turn everything that is relevant over to the defense. And when you get these Brady violations that pop up, it's because, and they often seem like they're late in the game, it's because in Illinois, we have almost no way to know unless we send out our PI to talk to a witness that turns out that they say, oh yeah, you know, the cops were here. They interviewed me not once, twice, a couple of times. And then we go back and check the discovery and we see that we only have one of the interviews.
Right.
And at that
And
point, we know
unless
that
there's, like, some kinda hint in what we're reading where we're like, "Well, it seems like they would have done something else. It seems like something should have happened before this."
right.
But
Yeah.
yeah.
I mean, and that's bullshit having to read through the tea leaves to get evidence. You know, I mean, if you got the guy under arrest that you're convinced is the guy, turn all your shit over and let's go to trial if it need be. And if you got the guy and you got all the evidence, more likely than not, it's pleading out. When a state pulls this kind of stuff in slow plays or withholds evidence, it cannot give you a warm and fuzzy feeling if you're the families. It just can't. It can't give you, it does not exude confidence in the case when the state seems to be playing hide and seek with evidence.
Yeah, it doesn't show any
Paragraph 11.
doesn't show they have any confidence in their case either.
Who? That's who I'm talking about. The only person I'm talking about is the state.
Right.
You know what I mean? Like, who did you think I was talking about? The defense? I'm not talking about
No,
the defense.
I thought you were just saying, like, in general, like, it doesn't have make other people have confidence in the case. I'm
Well, that's
sorry,
what
I
I'm
was
saying. Right. I can't make yeah, like, I don't think, like, were you not listening to me, Bay? It
No,
seems
I
like it.
am.
Oh,
I was actually texting our daughter trying to get her to bring me water,
ah,
but I was
there's
saying that, like, they don't even have confidence in their own case, or they would.
well, that's what that's but right, I
Right,
said
so
that.
yeah,
So,
I was
like,
texting
that's
her
what I
too.
mean. It doesn't give you a warm and fuzzy about them, the confidence in their case if they're feeling that compelled to hold back evidence. All right, 11. So this breaks it down. Because law enforcement and the prosecution are in total control of what evidence is ultimately turned over to the defense has no choice but to hope that the state of Indiana turns over all relevant evidence, especially exculpatory evidence. The defense simply does not have the luxury of knowing what relevant / exculpatory evidence that the state possesses and has turned over versus what relevant / exculpatory evidence that the state of Indiana possesses but has failed to turn over. Again, as defense attorneys, we cannot know what we do not know exists. We are not psychics. We rely on that good faith of the state that they're going to play by the rules, that they're going to be ethical, that they're going to turn over what they're required by law to turn over in reciprocal discovery. And that paragraph broke it down beautifully. 12, over the course of this case, the defense has learned of certain evidence referenced in other discovered documents or mentioned from other sources or from exercising common sense that it had caused the defense, to believe that said evidence does exist, but that the prosecution had failed to turn over said evidence to the defense. And then the defense later determined that the prosecution did in fact possess those items, but failed to turn those items over to the defense until requested to do so by the defense. This harkens back to they don't need to make specific requests. That is not how this game works. They have to turn over all the relevant evidence. Brad and Andy don't have to sit there and try to figure out what may exist, like exactly what you're talking about, from like being able to like decipher clues, to figure out that, oh, well, it appears that there was something that was an interview that was recorded. Where's the corresponding CD or flash drive with the it's not supposed to be like that. Yet in this case, it seems like it's very much like that. 13, the history of the prosecutor failing to turn over all relevant evidence to the defense has caused great concern to the defense. 14, over the course of this case, many of the items that the state of Indiana has failed to provide to the defense in a timely manner are what the defense would label as major pieces of evidence, even exculpatory evidence. And I just have to say that, and again, for the search for justice, the most catastrophic thing that could ever happen is that if Rick Allen happened to be the perpetrator of these crimes, and Nick McClelland has handled this case in such a manner that this thing goes to trial, and Brad and Andy are able to establish reasonable doubt within the minds of the jury, and a guilty man walks, that's the most catastrophic finale that could possibly happen, right? I mean, no one wants a murderer, a double murderer, to walk free ever. That's
Well,
not
no one
that's
wants
not the
an
way our system works.
innocent man in prison either.
And that's the other side of it. And that's the other side of it. I mean, the point of me bitching and complaining and talking about the Constitution constantly is because it is the guideline by which we operate in this country, especially with respect to our system of justice. There are rules for a reason. There are laws that are in place for a reason. This is not a perfect system, far from it, but it's the best one on the planet. And in the search, in the eternal search for justice, and justice is like nothing's giving grieving parents their children back. So, I mean, can there ever really be a full measure of justice? No. But in terms of what small amount of justice we can dole out to victims' families, it's a conviction. In some cases, they'll put the offender to death if that is something that families desire, an eye for an eye type thing. Like, I'm not going to get on my soapbox, but to me, there's no worse punishment than spending the entirety of your life in a 6x8 cage. But that's just my opinion on it. Without even getting into the morality side of it, there's no worse punishment than spending the balance of your life in a cage. 13, the history of the prosecutor failing to turn over all relevant evidence to the defense has caused great concern to the defense. 14, over the course of this case, many of the items that the state of Indiana has failed to provide to the defense in a timely manner are what the defense would label as major pieces of evidence, even exculpatory evidence. I realize that I read those already, but I wanted to read them again. 15, many of the items of the state of Indiana failed to provide to the defense in a timely manner were only provided after the defense had specifically requested the item that it came to learn it existed, but the state of Indiana had failed to turn over. For example, one of the more important pieces of evidence in this case is the data retrieved from the phone found at the scene where the victims were found, as this piece of evidence containing data concerning the down the hill video and other important information. 17, this phone and the data contained on the phone has been available since 2017, yet the defense did not receive the data from that phone by the deadline of December 14th, 2022, as designated by the rule. 18, the defense, knowing that this evidence simply had to exist, finally sent an email to the prosecutor on June 17th of 2023. I'm going to assume that paragraph 17, that deadline was supposed to read December 14th of 2023, not 2022. 18, the defense, knowing that this evidence simply had to exist, finally sent an email to the prosecutor on June 17th of 2023, requesting the data from several phones, including the phone in question that belonged to Liberty German. That is stunning to me.
Is he saying that they didn't get the raw data, like, for the video and all of that stuff? Is that what he's talking about? Or just her, like, her history? Or
I'm assuming all of it. Like, he uses a broad term, yet the defense did not receive the data from that phone by the deadline of December 14th, 2023, as designated by local rule. To me, data is all of it, the whole kit and caboodle. 19, the state of Indiana did not provide the phone data from Liberty German's phone until September 8th of 2023, nearly 9 months after the state of Indiana should have turned over that evidence. And
so he
nearly
is saying 2022 for December.
I don't know.
Well, he just said how many months later, 2023.
So he said, all right, okay, maybe he didn't fudge on that date. I think there's one place that I definitely saw a typo on a date, but no matter. The state of Indiana did not provide the phone data from Liberty German's phone until September 8th of 2023. Yeah, you're right. Nearly 9 months after the state of Indiana should have turned over that evidence, and nearly 3 months after the defense specifically requested that evidence, even though the defense is not required to make a specific request for relevant evidence. 20, most of the other items requested in that June 17th, 2023 email to the prosecution still to this day have not been turned over to the defense. This includes data, reports, and other information related to the images of the bridge purportedly taken on Liberty German's phone at 2:05 p.m. on February 13th, 2017, as well as an image of Abigail Williams walking on the bridge purportedly taken on Liberty German's phone at 2:07 p.m. on February 13th, 2017, both purportedly sent through Snapchat.
What? Purportedly? He doesn't have this type of shit? It's like, to me, I have to say, I don't know how the hell you're going to trial, because you've got to analyze the data to realize what were the times things happen, and what were the space between things happening. And
well, you and I were having the conversation, right, about what the remedy is here in terms of, typically a remedy, if the state fails to turn over evidence that's not exculpatory, the remedy is that the state is barred from introducing that at trial, right? Here, if you have exculpatory evidence, obviously the defense does not want that barred from being into evidence. So I don't know what the remedy would be with respect to the state in terms of a punishment. You know what I mean? It's like, I think at this point, knowing that the trial is bearing down on everybody, they just want the shit so they can get it to an expert. I mean, and at this point, if they don't know if it's exculpatory or inculpatory or neither, they're not in a position where they're going to be able to say, all right, we're asking that the evidence be barred, for their failure to disclose it in a timely fashion. We'll see how it plays out. 21, the week of August 5, 2023, the defense took several depositions. At the conclusion of that week, it became clear to the prosecution that the defense was pursuing information concerning certain Odinus that had been investigated by 3 law enforcement officers, Todd Click, Greg Ferenczi, and Kevin Murphy. 22, on or about September 8th, 2023, nearly a month after said depositions, the prosecutor provided a daunting amount of newly discovered evidence,
Wait, on
including
what
a
date?
letter, September 8th of 2023. These dates are all right.
No, I
So
gotcha.
this is
I
after the
missed it.
deps. So after the deps take place and McClelland catches wind that they're on this Odinus thing, at that point, a month later, or nearly a month later, the prosecutor provided a daunting amount of newly discovered evidence, including a letter from Todd Click's lawyer. Here, I'll blow this thing up a little bit so y'all can read it too.
I mean, I don't know if other people can actually read it. I'd love to, but I mean, I can't see that.
I think our subs can, our viewers can see it. On or about September 8th, nearly a month after said depositions, the prosecutor provided a daunting amount of newly discovered evidence, including a letter from Todd Click's lawyer discussing Click's concerns. Essentially, that the prosecution might be unaware of law enforcement's investigation into Brad Holder, Patrick Westfall, Elvis Fields, and others Click believed were likely involved in the murders, and others that Click believed were likely involved in the murders. This letter and its contents were highly exculpatory. 23, upon receiving this missing evidence, the defense was surprised/shocked to learn that on May 1st, 2023, the prosecutor's office signed for the Todd Click letter and the exculpatory evidence and information contained in that letter. Yet, and this is in italics for emphasis, yet failed to alert the defense as to the existence of this exculpatory evidence or discovery until after the prosecutor knew for certain that the defense would definitely be calling Todd Click in for future depositions. Parenthetical, at which point in time the defense would most assuredly learn of the existence of this exculpatory evidence, i.e. the letter. McClelland did not turn over the letter and its exculpatory material to the defense until September 8th of 2023. It took McClelland 131 days to turn over this exculpatory evidence, and it was only turned over after McClelland knew that the defense would ultimately find out about the exculpatory evidence. 24, the prosecutor offered no explanation whatsoever as to why he had held on to the exculpatory evidence for several months and only provided it to the defense once it became obvious that the defense would learn of the existence of that exculpatory evidence. Certainly, the defense would have been much further ahead in their defense of Richard Allen had the prosecutor turned over the Click information in a timely manner. Certainly, the defense would have been even more prepared for the August depositions had the prosecutor turned over that exculpatory evidence. Paragraph 26, between September 8th of 2023 and October 6th of 2023, approximately 90 days before the January 24th trial date that had been set, the state of Indiana dumped 14 hard drives, 5 flash drives, 1 disk, and certain e-discovery on the defense, including several videotaped interviews of third-party suspects that the defense had focused on when deposing law enforcement in early of August 2023. The state of Indiana provided no explanation whatsoever why they had not turned over to the defense this massive amount of evidence, exculpatory or not, 9 months later than required under local rule, and a month after the prosecution learned that the defense was pursuing a defense that certain third parties were involved in the murders. Much of the late discovered / missing evidence pertained to the focus of law enforcement on certain suspects involved in Odinism. It was apparent that the defense had not alerted the state of Indiana as to their strategy to pursue the Odinist angle in defending their client, and therefore the likelihood that the defense would not talk to Todd Click, who would then reveal the existence of the letter. It is highly likely that the prosecutor would have never turned over that exculpatory evidence to the defense. I have to agree with them there.
I mean, honestly, I am dying for her to get a little bit outraged at the prosecution. I mean, or to something, because if this all plays out and he's actually got more evidence that he hasn't turned over, I swear she needs to do then, I don't know, a special prosecutor to go in and look at all the discovery, make sure it's all been tendered. Somebody's got to do something. But that's how I
Well,
felt like when we were going through the same kind of shit
I
in
mean,
Garcia.
the somebody is the judge. That's who's supposed to be doing something. And we know what the result thus far of our expectations of her doing something to reel this case in, to get it back on track. At this point, this is not an us versus them scenario. People need to understand that in order to get to trial in a
In
case
order
of
to
this
convict
magnitude,
somebody, right, they need to give the discovery.
they have to give the discovery. And moreover, there's got to be some kind of modicum of cooperation between the state and the defense in order to get this thing moving in the right direction and in order to get it prepared for trial. Now, that doesn't mean that they're going to play nice along the way, but they're going to be civil and they're going to do what they have to do to get the thing to trial. And and if that's not happening, you rely on a judge to make it happen. If the prosecution and defense seem incapable of playing nice, that is the role of the judge to say, cut the shit and do what you need to do to get this case to trial. And she's not doing it.
Yeah, I mean, she
And I
should
don't
have
know
done
why.
that without setting this hearing. I do have to say, and I don't want to get us like completely off because I want you to keep going, but I think because of the fact that she set a trial date, maybe that speaks to that she's got no intentions of, putting anyone in jail or taking lawyers off a
She had no
case.
choice. Like people acting like that there was a choice of her not setting a 70-day speedy demand. That was not like up
No,
to
no,
her.
no,
She
but
had no.
did she have to provide the date yet? Like,
Yes. What
hmm,
what do you mean? Like, what do you think she's gonna wait a week before trial? I mean, it would had to be within 70 days of the request. She made it a
right.
couple days earlier. My calculation was like the 15th based on what I was doing, but I was like counting on my phone calendar. So, I don't even
Yeah.
know.
Well, it's
Um,
smart to do that because a witness doesn't show up and they can't start for a day or something weird happens, you know.
yeah, no doubt. No doubt. Um, all right. Okay. Let's see. What was I on? I think 29. The very last discovered item the defense received before the prosecutor requested the defense be kicked off the case was the geo-fencing evidence that the defense believes was received on October 6th of 2023. Okay. This geo-fencing evidence was received nearly 10 months after the state was required to turn it over and contained what appeared to be highly exculpatory evidence concerning a variety of important matters, including the phone numbers of multiple people who appear to either have been at the crime scene or within 60 to 100 yards of the crime scene during the very times when the victims were purportedly being murdered. I mean, what?
Read it again for
Should I
all
read that
those not
again?
listening. Yes.
For all those in the back? All right. So, this geofencing evidence was received nearly 10 months after the state was required to turn it over and contained what appeared to be highly exculpatory evidence concerning a variety of important matters, including the phone numbers of multiple people who appear to have been or to who have either have been at the crime scene or within 60 yards to 100 yards of the crime scene during the very times when the victims were purportedly being murdered, according to the state's timeline provided in the probable cause affidavit. I mean,
You know what's crazy in the federal court, and I can't give the exact time right now, but it's like some crazy time before trial that they don't have to give you like phone numbers and addresses of the witnesses. I had that issue in one of my federal trials. I was trying to go out and interview a bunch of people, so I was trying to get it early, and the judge's like, "They don't have to give it to you until." Yeah, I should know it off the top of my head, but I can't think of it. Days before trial. Like, okay, so that's how much time I have to do my own investigation?
Yeah, seems like defense side investigation doesn't really get much love from judges, in general.
No.
Um, 31. In this late discovery, the defense found a map prepared by someone, presumably law enforcement, that appears to track the movements of these people in and around the crime scene the afternoon. And I'm assuming that this is supposed to be February. This is the date that I was talking about. Around the crime scene the afternoon of, he has December 13th. I'm fairly certain it's supposed to be February 13th, 2017, including between 3:02 p.m. and 3:27 p.m. at or very near the location within 60 to 100 yards of where the bodies were ultimately found the following day. I mean, what? It's upsetting. It just is, it's upsetting. Like the more, and look, I say it all the time. I won't know until trial what's what, but man, like when something looks like a duck, quacks like a duck, is it a duck? And this shit looks like a railroad job to me. And that's without me knowing jack shit about the evidence other than what I've seen in the PCA and what I've
Well, I mean,
read
it's
and
still kinda stuck in
memo.
my craw about them deleting. Oh, oops, we overwrote it.
Oh, like that's you talking about the interview of Brad Holder that got deleted over?
Oops.
I
Ooh,
mean,
no harm, no foul. Wasn't
I
there a
still
motion
don't
filed?
know.
Did she just deny it or whatever happened?
I don't know. No, she hasn't denied that yet. And I speculated a while ago that I thought that this second hearing or purported second hearing on the 18th, because she set two dates or two times on the same date. She's got a 9 a.m. date and then a 2 p.m. date on the same date of the 18th of this month. And I'm assuming that Hennessy's going to be in there chopping wood early, that they're going to do this ridiculous motion that he's got to come in there and crush. And then in the afternoon, it was my understanding, as I couldn't think of any other pending motion, that they were going to handle the motion to dismiss, the defense's motion to dismiss, relating to exactly what you're talking about. Now, I saw somewhere an order relating to that actually verified, but I don't know if it was a fraud. Like I can't remember where I saw it. Like, my people typically get me copies of orders right away. I'm still not seeing it on the docket. I don't know. I honestly don't know, Allison. I wish I did. We should know. We should know. I mean, that's 100% is a we should know. We should not have to be guessing, nor should anybody involved with this case have to be guessing. I am assuming that Brad and Andy know what's being heard that afternoon. I would hope. And McClellan, for that matter.
I mean, she's had to have learned
I,
something, right?
can we make like at this point it's way too far gone to make any kind of assumptions towards the logical. Like that ship has long sailed in this case. Like, logic does not dictate this case. It's just not how it works here, you know. All right. Excuse me. Since their return to Richard Allen's defense, Allen's attorneys have specifically requested via email, February 26, 2024, that the state of Indiana provide all narrative reports relating to the geofencing data, as well as the documents related to the geofencing data. But the state of Indiana so far has claimed that no such documents exist.
Oh, so they
33.
don't know what it means? They didn't get anything. They got no information about what that information means, how it was determined, nothing.
Yeah, I mean,
Okay.
however they made the map. you know.
Well, it seems a little hard to make a
They
map without the
they
corresponding
clearly
data.
intuited it. It was
Mm.
intuition. It was the intuition map. They didn't have the data. They just were able to intuit it from whatever, the ether. 33, again, the defense is at the mercy of the prosecutor's claims of existence or non-existence of such evidence. 34, as it relates to the geofencing evidence, it would be shocking that law enforcement would take the time to put a map together tracking the movements of certain phones in and around the crime scene between 12:39:54 p.m. and 5:49:06 p.m. on February 13th of 2017, but would then not follow up with a detailed narrative report concerning the geofencing analysis of that data. I'm going to read it again. As it relates to the geofencing data or evidence, it would be shocking that law enforcement would take the time to put a map together tracking the movements of certain phones in and around the crime scene between the times of 12:39:54 p.m. and 5:49:06 p.m. on the 13th of February, but would then not follow up with a detailed narrative reporting or detailed narrative reports concerning the geofencing analysis of that data. That makes sense, right?
Well, absolutely. I can't even tell from that if he's saying that there's a corresponding, because I don't know if is he getting redacted reports, like where phone numbers are redacted? Like that's what I'll typically get, like in a federal case. Like I'll get the narrative and the interview and the witness's name, but not a phone number or an address, so that I can't. I mean, it's like a weird game.
It's weird. It's not even weird. It's shady. I don't know how else to put it. It's dirty pool is what I call it, you know. And
It's
I mean,
always
we've
dirty pool.
experienced dirty pool
It's
with
almost
prosecutors.
always dirty pool.
It's almost all look, I mean, they got a huge amount of time, resources, and money invested in Rick Allen being the guy. And you're seeing every bit of that in terms of them pressing to get this conviction. This is what it looks like, just in case y'all didn't know. 35, yet the prosecution claims no geofencing report exists. However, the defense has heard this type of answer from the prosecution in the past, only to learn that the prosecution's claims that the documents did not exist weren't true. A,
And I
it's going to
just
give
want to
some.
say, if he thinks there's something that's like work product or not subject to being turned over, I mean, I guess I'd have to look at the specific rule in Indiana, but I would assume, as is typically done, then they have to turn it over to the judge for the judge to make an in-camera inspection and determine if it's something that has to get turned over. Because if somebody's getting the information orally, I mean, they can't avoid discovery like that. They can't just be like, all right, what I want you to do is just tell me the stuff. And then the prosecutor makes his own notes, which would then be work product. I don't know.
I don't know either. I don't know either. All right. So he said, however, the defense has heard this type of answer from the prosecution in the past, only to learn the prosecution's claims that documents did not exist weren't true. Now he's going to give some examples. A, within the last 2 weeks, the defense deposed the state's phone dump expert, who presumably will be testifying concerning the data found on Liberty German's phone. B, that before that deposition, the defense had emailed the prosecution on February 26, 2024, seeking reports related to the phone dump of that particular phone in order to prepare for said deposition. C, the prosecution responded to the defense, claiming that there were no reports related to the phone dump from the expert. D, then at the deposition, minutes before the deposition began, the prosecutor handed over 2 to 3 pages of notes that the state's phone dump expert had made, providing the defense zero time to review as part of its preparation for the dep, and providing no opportunity for the defense to meet with its own tech expert in order to learn what questions would be wise to ask the state's expert at said deposition. You and I were talking about that other night. I mean, that's one of the primary reasons, aside from testifying on your client's behalf at trial of experts, is to to have them educate us in whatever their area of expertise is in terms of developing, either if you're in a state where you can depose witnesses, or developing your cross-examination. I mean, we rely on that. Like, absolutely. The prosecutors handed over these notes without explanation, with no apparent reasons as to why the prosecutor had previously told the defense that no such documents exist, when in fact they did. The prosecutor's denial of the existence of certain documents regarding the phone dump before the deposition, followed by the unexplained production of certain documents within minutes of the deposition, sadly was not surprising, but highlights, once again, the less than forthright style in which the prosecution has been turning over evidence to the defense dating back to the beginning of the case. 36. Furthermore, because of the lack of candor concerning the existence or non-existence of certain evidence, the defense cannot be sure whether certain documentation exists concerning geofencing analysis, even though the prosecution is claiming that no such documentation exists. 37. Since rejoining the case, the defense has sought out the names of geofencing experts who analyze the geofencing evidence for purposes of preparing for depositions to determine if the state's expert has an explanation as to why the geofencing evidence displays what appears to be extremely exculpatory evidence of people walking in and around the crime scene during the times when law enforcement is claiming that the murders were taking place. At first, the prosecutor refused to provide. At first, the prosecutor refused to provide the names of his experts, but then told the defense he would ask his investigator. 38.
I'm so freaking I need an Indiana lawyer. You're telling me that he doesn't have to produce his expert reports and his experts' information so that the defense can prepare to. I don't get it.
I have a feeling we've got some Indiana lawyers here in our chat who may or may not be under gag orders. I don't know. Yeah, I should have hit Shay up because I know Mike Losbrook's under he's under a gag. He can't talk. Hennessy's under a gag. He can't talk. Obviously, Brad and Andy can't talk. 38. This is a rough one. This one's gonna blow your mind a little bit.
All right, good. Because I was.
You want me to read it?
No, yeah, I do.
Okay. All right. Again, specifically, someone prepared a map which tracked the February 13th, 2017 afternoon movements of multiple phones in and around the place where the victims were ultimately found the following day. Particularly, some of these movements appeared to have occurred between 3:02 p.m. and 3:27 p.m., either at the scene where the victims were ultimately found on February 14th, 2017, or within 60 to 100 yards from that site, and none of the phones or people associated with the phones have any affiliation with Richard Allen.
What in the hell is going on? Are they so wait, when did they first learn this? I just don't understand why they're not in on, me, I would be in on an emergency motion. Emergency motion for the fucking immediate disclosure of this information. Like, I just don't.
It's easier to sit here and say that what we'd be doing, but it's like when you know what the end result's going to be. I'm not suggesting, because obviously they filed this, so they brought it to the court in terms of a pleading, but in terms of the emergency nature, do you think Gull's going to be outraged?
Well, what I still don't get, and I know that Kara explained it to me, like how you set something for hearing. How do you get something heard? Like,
She texted to you. You could actually look at your message, and I think I saw she sent you a long written response. All right. To me, that's stunning. What they're saying right there is that they've got an unspecified number of phones, which are presumably connected to humans, walking around either where the girls were discovered exactly or within 60 to 100 yards, which to me is inexplicable that they either didn't see something or they aren't the ones that didn't do something or did do something. Either way, they had to have seen or had to have been participating, one of the two. And what's the most significant is that none of those phones or people associated with those phones have any affiliation with Rick Allen, which I'm assuming includes that none of those phones are Rick Allen's.
I mean, have they had his phone examined? It should actually to find out where he was all at these moments. Maybe he doesn't have the same phone.
Yeah, it's hard to know. Following the request for the identity of the geofencing experts, the prosecution claimed that he had no idea who analyzed the geofencing data, but then the state of Indiana provided the names of 4 people that may be called as the state's expert witness of geofencing. So he says, I don't know. I don't know who did it. Like who's setting, so like I guess Nick's story is that his PI, whoever he's got, or his investigator, whoever's his, like, I mean, who is that? Is that Liggett? Is that Holman? I don't know who it is. Who's his pit bull? Like who's doing his bidding? Who's his fucking guy? You know, because like this guy's the guy that's setting up expert witnesses for the state. They're entrusting that to law enforcement to find his expert witnesses. Is that what Nick McClelland's saying? Where'd you go? I lost her. She gone. All right. Okay, following the request for the identity of the geofencing experts, the prosecution claimed that he had no idea who analyzed the geofencing data, but then the state of Indiana provided the names of 4 people that may be called as state's expert witnesses on geofencing. 40. Nowhere in the discovery has the defense located any narrative reports or other documentation or an analysis of the geofencing data from any of the 4 identified states' geofencing experts. Oh, where'd you go?
Sorry. I don't know.
I missed you so much.
Aw.
You're so gone. 41. Nowhere in the discovery has the defense found any documentation negating the defense's analysis that the geofencing evidence shows multiple people were found in and near the crime scene at the time when law enforcement claims the murders were occurring. I mean, it's crazy.
Wow, 42 is exactly what I was asking you about.
Well, that makes me really want to read it right away. Additionally, the
insane.
defense has reviewed all discovery provided by the state of Indiana, has not yet found a single interview of any of the people whose phones, according to the geofencing data, were found the afternoon of February 13, 2024, moving in and around the location where the bodies were ultimately found the following day at times when the murders would have taken place, according to law enforcement timelines. I'm going to read it again because it bears repeating. Additionally, the defense has reviewed all discovery provided by the state of Indiana, all of it.
Well, I like this is because I've already like started peeking at 43. I'm having a mental breakdown.
No peeking. No
Sorry.
peeking. No peeking.
Sorry.
Additionally, defense has reviewed all discovery provided by the state of Indiana, has not yet found a single interview of any of the people whose phones, according to the geofencing data, were found the afternoon February 13th, 2024. I'm assuming that means 2017. Like Andy gets like excited sometimes in these pleadings and like messes dates up. So I'm assuming that he's talking about the date of the crime, right?
Gotcha. Right.
Okay, so we're found the afternoon of February 13th, 2017, moving in and around the location where the bodies were ultimately found the following day at times when the murders would have taken place according to law enforcement's timelines. I mean, the thing speaks
Incredulous.
for itself.
Either it's a lie or they're not really investigating this crime. I mean, it's only one of the two things exist. And if I
Like a
am
lie is to whom?
that by the state not producing those reports, because clearly we're supposed to assume no reports have been turned over, no interviews happened. So that would mean law enforcement did not interview any of the people who are present. I'm so irritated right now.
Are you irritated, babe?
I am.
It's pretty irritating. For us, imagine what it would be like to be the defense attorneys, or even worse, Rick Allen, or even
Well,
worse, the
to be
victims'
perfectly
families.
honest, they're not ready to go to trial. The judge needs to do something. Like,
Yeah,
remember
Veronica,
if you remember in the, what was the woman and the demons and the killed her kids?
Lori Vallow?
Yeah, Vallow. The judge in her I know the judge in her case put like a deadline that every single thing had to be turned over, or no, I think it was actually his case,
No,
because
it was
was it
Vallow.
hers?
What they
Right. So
Yeah,
that's why
they
she didn't
slow
have the
played
death
it.
penalty.
That's exactly why she didn't have the death penalty.
That judge wasn't messing around.
That judge was not playing. I mean, that was, to the extent that now they're all excited they're going to try her in Arizona, where they also have the death penalty, so they're hoping that they can kill her there.
I mean, the judge should be telling the police, if there's something that you guys haven't turned over to the state, you have until X date, and then the state has until X date to turn it over to, or like all hell's gonna rain down on somebody.
All
I
hell
have to tell
breaking
you,
loose.
if this was like, I don't know, I can't imagine that, no matter what side of the table you're on, which, as far as I'm concerned, we should all be saying we don't know yet.
Right. That's the only thing you can say.
Right.
Anybody who's saying anything definitively other than the attorneys on the case who know the evidence is full of shit.
Sort of know the evidence clearly, according to
Well,
this.
they know the evidence that's been tendered to them, right? They don't know the evidence that hasn't been tendered. And there's more. The hits keep on coming. We're not done. We've got another 24 paragraphs.
All right,
All
keep
right.
going.
The defense did locate very limited background information concerning one of the owners of one of the phones, but did
It's
not
not
locate any.
supposed to be a game. It's not supposed to be a game where you don't have, like, the just very clear background information for every single one of the owners.
I agree, obviously. The defense did locate very limited background information concerning one of the owners of one of the phones, but did not locate any narrative reports, interviews, or notes concerning the owner of the phone. I mean,
Maybe
like
they just decided not to
I don't
investigate the
care if you're
crime.
prosecution side, defense side, neither side, fence, what if this doesn't concern you as to the investigation or lack thereof that took place in this case for 5 years. This isn't like a case that they turned around and solved in 3 months, and like where you can maybe pick apart the fact that they were a little sloppy or there was a rush to judgment or
'Cause I'll
whatever.
tell you,
This is 5 years, man.
in Garcia,
Like,
they really left no stone unturned. They did follow every lead, interview every person, tried. If the state's gonna sit here and say they did not, first of all, I don't know who it was. I'm sure everybody else does and you do, but there was this assertion by, either someone in the police or the state's attorney's office that there are other suspects out there, that they are looking for other suspects. How in the hell are you looking for suspects if you're not investigating the people that are in and around the crime scene, or where the body's found around the time that the crimes happened and the bodies were left?
I mean,
We
how
just want to
long
keep
do we have
killers
to
walking around killing people. Maybe we, hopefully they won't kill anybody else.
is a is a country that at this point, those who care all have their eyes on this case. Like how long do we have to wait collectively before we're all fucking outraged? And like this isn't the Odin shit. Like if like you were of the mindset that the Odin thing was fantasy or fiction or some smoke and mirrors bullshit by the defense, that's fine. That's your prerogative. And you know what? A trial
not.
that may bear itself out. This ain't that. What we're hearing about right now is law enforcement's utter lack of any kind of real investigation into this thing. Instead it was Doug Carter with his press conferences, shaking his fist and telling the killer, we're going to find you. We're going to fucking find you. Your days are numbered. And instead of going out and I have no choice at this juncture but to assume that what Andrew Baldwin is drafting in this particular motion is true. Like,
I mean, anyone who's saying it's not true is just I don't have time for it. I don't have time for it.
They don't
Lawyers are
understand.
not.
Like they think this is a game of Clue. Like we can just fucking fudge around as lawyers and make shit up. That is not how the practice of law works. And if that's how you think it works, you need to get the fuck out of making content in true crime because you're a menace to what's really going on. All right.
Because
Okay.
I know the people have got questions, and I'm still dying to hear what else there is.
I know. All right. It pisses me off, man. Like I've tried to maintain like a modicum of like being reasonable, but I mean, how much can one human being, let alone a country of human beings, take? Ugh, it's like the more you read, it's just like, what is going on here? Okay, it would be shocking if the owners of the phones of these phones were not interviewed when their movements were tracked and then replicated on a map depicting their movements around the crime scene based on geofencing coordinates. Yet the defense is not located in any interviews, any of the interviews of the owners of these phones. I mean, like, is there a world that exists? So what we can glean from this is that these are not the witnesses that saw Bridge Guy. Okay, these are not the witnesses contained within, because they've been interviewed. We know they've been interviewed.
But it also sounds like they don't have the they don't have actual identifying information. One of those paragraphs said, well, we were kind of able to figure out who one person was, and we know we don't have an interview from them. Like, that's why he was asking for like the data. Or
I mean, does this map like have the phone numbers? Like, is that what it looks like? Like area code, whatever, and the exchange. Like, I mean, is that the way they're indicating? Like, this is where this phone was. We have 4 phones.
Well, no, because then
he'd be able to,
like, he'd be able to call the number and figure out who it is.
I mean, right? I don't understand. So they're getting the geofencing data from the towers, I'm assuming. I mean, that's where they're getting it, or from the various carriers that have a lease on those towers, or whose tower it is, or if it's a tower that's used by multiple
Here, I'm going to just say it outright. If, okay, because I'm going to assume that they were interviewed. I'm going to assume that police want to catch killers. They want to find either the criminal or a witness to the criminal, so that they interviewed these people. The only reason not to interview the people is if you don't want anyone saying anything that's going to mess up, your little scapegoat thing.
Right. Or there's something far more nefarious going on, that this is like I don't want to be the tinfoil hat guy.
I mean, it's not tinfoil hat.
Well, like, all I'm saying is when I see shit like this, I start thinking like corruption on a massive scale, to the extent where, You know, I'm talking like drug ring, cartel type shit, meth trade type shit, where there's a business that's being operated and people are being protected. I mean, this is inexplicable to me. Somebody needs, like, we all deserve answers to this. That's where I'm at with
Well,
it.
these guys are not. I wouldn't go to trial. I would be looking for those. I forget how many number he said of witnesses, and I would be
I mean,
filing a
it's easy to
motion.
sit here and to say that you wouldn't go to trial, but I think that there's a legitimate concern that Rick Allen might not make it to trial, honey. But when you look at what we're reading here with respect to what would, like, to me, this appears to be a cover up. Like if anybody in the chat, especially if you're on the other side of this, can give me a reasonable explanation as to why none of these people were interviewed, I'd love to read it. I'd really love to read it. I really would.
Again,
You know,
they
because
went on national television and said there are other killers out there. Why in the hell wouldn't they be interviewing these people to find the other killers, potential other killers? Or you just you know,
yeah, I don't know. I don't know. It's disconcerting to say the least. And that's being kind. Again, someone in law enforcement summarized these movements by replicating them on a map, yet no narrative report can be found to explain why law enforcement reduced the movements to a map of the multiple people using multiple phones at or near the crime scenes at the time the murders were purportedly committed. While it is possible that geofencing is not what appears to be, or perhaps was later debunked in some document that has not been turned over to the defense has found no documentation that dispels that the geofencing appears to be highly exculpatory in nature. The defense is attempting to verify what the geofencing evidence appears to show, and based upon the map that tracks the movements of multiple people, to verify what law enforcement also apparently believes the geofencing coordinates show. I mean, look,
and just so everybody
let us
knows,
not.
they've got to turn over their experts. Like, I don't understand what that meant, where he's saying that the district, is it a district attorney here or a state's attorney? What is he?
I think he's the
You don't
state's
know.
attorney.
Okay, so the state's
It's the state's
attorney
attorney.
is like, well, whatever. McClellan's like, I'm not turning
Maybe it's
over my
DA.
expert reports. Like, the defense has the right to have their expert use the very same data the state used and, examine it. Or if it's something like, it's just,
Um,
yeah, who can forget
okay.
that debacle? 48, the Purdue Professor debacle.
Yeah, it's okay. 48. After the debacle involving the identity of the Purdue professor, the defense has no faith at all that the prosecution will produce evidence such as geofencing analysis as required under local rule 08 CR 00018. 49, as detailed in the Franks memorandum filed September 18th, 2023, as well as the defendant's additional Franks notice filed October 3, 2023. Since October 10 of 2023, the defense has asked the prosecutor to identify the Purdue professor, who we know at this point is Turco, whose findings thwarted investigative efforts to look into Odinism as being involved in the murders. According to Sergeant Jerry Holman, the Purdue professor had reviewed the arrangement of certain sticks left at the crime scene and concluded that the sticks found on the girls at the crime scene, according to Holman, did not represent, quote, Odinism or any type of cult worshiping or any type of group that would have committed the crime, end quote. Holman Depp at page 63, lines 15 through 20. 51, however, after his deposition, the defense sought the identity of this Purdue professor who altered the way that the case was investigated. No one from the prosecution or law enforcement claimed that they could remember this Purdue professor's name. 52, after the defense made several requests from the prosecutor to identify the Purdue professor for purposes of conducting a deposition, the prosecutor sent an email to the defense on September 6, 2023 that read, quote, as stated before, we are trying to identify the Purdue professor, but no luck yet. Detective Holman has reached out to the FBI and Purdue and has not gotten a response yet. We will continue our endeavors, but may not be able to identify him or her, end quote.
All right. So I just want to say that not in a million years does a cop go speak to someone where they don't write down the name of the person they are talking to. But the only reason there wouldn't be a report about someone they interviewed and what that someone said is because they are concealing the information. They don't want to turn it over to the defense. And if anyone, no matter how pro prosecution you are, thinks that that is the way to get justice, truth, fairness, anything, then I guess maybe I'm the one living in the wrong country.
It's hard to, I mean, I don't know. It's kind of, I mean, you and I have gone through the gut punches of being defense attorneys and just
I still get
the
shocked
utter,
by it.
but it's never ending. Like
And
just
this is very typical. This happens a lot of the time, just so everybody knows. Everyone who wants
right.
to shit all
It's like the
over
crushing
defense
power
attorneys.
of the state. It's just the crushing power of the state. And then you have judges that were former prosecutors as a majority of those who sit on the bench. And all right. Okay, so 53, this response from the prosecutor seemed utterly preposterous. It had been nearly a month since the defense first made its request for the prosecutor to identify the Purdue professor, and the state police, with all the resources at its disposal, claims that it was unable to identify the Purdue professor, even indicating that they may not ever be able to identify the Purdue professor. The prosecutor's email seemed implausible.
Oops,
54, the
deleted.
mere
Overwritten, sorry.
or disappeared, vanished. It's a specter. The ghost professor. The mere identity of the professor, the Purdue professor, is considered discovery that should have been turned over to the defense. His name and reports should have been provided to the defense no later than December 14th of 2022, according to local rule. Yet, on September 6th of 2023, the prosecutor told the defense that Jerry Holman and the vast resources of the Indiana State Police could not figure out who this professor was, nor did the prosecutor turn over any of the Purdue professor's reports. And just so people have an understanding, the way that the law works with respect to pleadings, like I'm sure that the other side is going to be, and when I say that, I'm talking pro prosecution folks, are going to be saying, "Oh, this is the defense trying their case in the press." No, this is the only way that you communicate with the judge is through pleadings. And in order to make the pleadings and to argue your case to the judge, you have to include these details. This is discovery issues. Like
I mean,
this
I don't
isn't
know
like this
where
isn't a
people
theory of
started to think
defense here.
that like defense attorneys aren't supposed to put everything, in emotion. The only way I won't do it is if I'm really holding something back that, that I want to argue at trial, like not make an argument that I want to,
Right. You want to try
keep
to
in my
take the
pocket.
prosecution by surprise. It's like the ace up your sleeve. If it's not discoverable and you didn't have to turn it over, like it's nice to try to surprise the other side. But played and hide and go seek with discovery that's required to be turned over ain't it. Like that's not what we're talking about here. 55. However, since getting back on the case, the defense has learned that Jerry Holdman did in fact learn the identity of the Purdue professor, Jeffrey Turco, on August 12th, 2023, through the Purdue Police Department, and Turco's identity was confirmed a few days later by other law enforcement. Holman even had possession of Turco's report, which contradicted Holman's August 10th, 2023 sworn testimony during the same time frame. Jesus. The information contained in paragraph 55, what are they doing? Like, what are they
And why is there
doing?
no discipline?
Well,
Ugh.
that's gonna come later. That's gonna come later, and it's not gonna come from Gull. You
No, I
know, I
know, but
mean, like,
what about the police force? Like, why this? I remember from either the Franks motion or whatever when they said that he lied in his deposition. I mean, is there some internal affairs unit investigating that? Some integrity unit investigating that?
for
The whole thing.
agencies that all have a vested interest in seeing Rick Allen convicted, the answer is unequivocally no to that question. No, there is no one. You've got the Indiana State Police. You
How
know,
many
I mean,
paragraphs
like
we have left?
thousands,
I gotta
thousands of
stop getting
paragraphs.
outraged.
We're just getting started. And look, if you gotta bounce like after this, like while I'm going through David's stuff, I understand. I mean, I'd
Well,
love you
we're
to
gonna
stay
talk about this a while before you do that, right?
for certain. Yeah, I want to see if there's some questions. All right, 56. The information contained in paragraph 55 above came directly from Jerry Holman's own report, prepared September 22nd, 2023. Holman's report was not made available to the defense until February 2024. Holman's September 2023, Holman's September 22nd, 2023 report exposed the following concerning the state of Indiana's intentional violation of the discovery order due to their attempt to hide the identity of an exculpatory witness. A, during the month of August 2023, the defense made multiple requests for the state of Indiana to identify the Purdue professor who, according to Jerry Holman and Tony Liggett, altered the way that the case was investigated. B, by mid-August 2023, Holman knew the identity of the Purdue professor, yet throughout all of August and September, McClellan told the defense on multiple occasions that Holman and or law enforcement could not figure out the identity of the professor. McClellan's September 6, 2023 email to the defense detailing Holman's inability to identify the Purdue professor was clearly not true. D, after the filing of the Franks memo on September 18th of 2023, Jerry Holman was forced to interview the Purdue professor before the professor learned that he was missing. Holman interviewed the Purdue professor the very next day, September 19th of 2023. Holman's September 2023 report memorializing his meeting with Turco is filled with multiple falsehoods and mischaracterizations concerning his conversation with Turco. In what appears to be an attempt to water down Turco's actual opinion that it was, quote, it was a given, end quote, that someone was trying to replicate a Germanic runic script, end quote. Holman memorialized Turco's conclusions as, quote, inconclusive, end quote. Despite how Holman drafted his report, Turco's conclusions were not, quote, inconclusive, end quote, whatsoever. Turco was clear in that his opinion and that of a Harvard expert that the sticks found at the scene were an attempt to replicate a Germanic rune script. The only thing that Turco could not say for certain was the intended meaning of the persons who left the runic script at the crime scene.
Every single time a police officer speaks to someone, it should have to be recorded from the moment that they have contact.
In this day and age, absolutely. There,
I
it's
mean,
There's no question. There's no question. I mean, like we are way past the days of notepads and scribbling shit down. We are in the digital era. Uh, it's inexcusable. It's like absolutely inexcusable.
no, I mean, but the requirement, the policy should be for every police department, there can be no interaction not recorded. Not the whole, we're going to talk, then we're going to put on the recording, we're not going to record, whatever. Because that's what people don't understand, that you're like, okay, and let's like take the prosecutor out of it. The prosecutor's getting the information the cop gives them. So if the
Right.
cop is like, well, that kind of sounded inconclusive to me, that's what the prosecutor knows. And for all we know, he could have thought that those guys really didn't know yet. You would expect, if that was true, somebody being screamed and yelled at. How in the hell do you not have a report? This better not be bullshit. If this is bullshit, you're losing your job. I mean, it's just The system is, and always has
Alley
been
rant.
broken.
Alley rant.
All right, go on.
Yeah,
Keep
by the
going.
way, I was agreeing completely with you. I'm saying that
No, I know.
like with the ease in which they can record every single interaction with every single witness is
Right.
it's like there's no viable explanation as to why that's not occurring.
Right.
Period. It's best practice. Triple I. Holman also attempted to deceive those reading his report when he, Holman, wrote in his report that Turco stated that no evidence or research indicated that those involved in Odinism, quote, practices ritualistic human sacrifices, end quote. Roman numeral 4. Holman chose not to include Turco's actual words, that the stick configurations were pretty clearly runic, and that he, Turco, quote, could certainly imagine that this was somebody's idea, that when you do human sacrifices, you carve runes. There are some poetic sources that would sort of support that idea, that somebody might have come across that scenario that seemed entirely plausible to me, end quote. Turco tape statement 15 to 1550.
Oh,
I mean, that's the receipts. That's the receipts. They're not making this shit up, people. Like, this is like, they're citing from the discovery, from the recording, from where that was said by Turco, the professor. I mean, if you're on the other side of this and you're not pissed, I have to doubt what your true intentions on this case are. Like, it's weird to me. Roman numeral 5, whereas Turco told Holman to his face that the people who placed these sticks on the girls clearly were attempting to create runes, and that it was entirely plausible that the perpetrator would believe that after a human sacrifice, they should carve runes. Holman attempted to deceive the reader of the report by implying that Turco totally disregarded the possibility of the involvement of human sacrifice. That is not what Turco said. 58. Holman certainly understood that on August 10th of 2023, he, Holman, did not tell the truth under oath at his deposition concerning the findings of the Purdue professor, then tried to hide the identity of the Purdue professor. While Holman was attempting to hide the identity of the professor, what Holman did not account for was that the Franks memorandum would be filed on September 18th of 2023, and that the Franks memo would call out Holman and McClellan for claiming that they could not figure out the identity of the Purdue professor. Furthermore, McClellan never once contacted the defense and alerted them that the Purdue professor had been found. 60. Furthermore, McClellan has still never explained to the defense why he, McClellan, had sent an email on September 6th of 2023 claiming that that the identity of the professor was still unknown, when it was later revealed that Holman had known of the identity of the Purdue professor several weeks earlier. 61. Additionally, McClellan never turned over the Purdue report until receiving an email from the defense requesting that he turn over the report specifically, again, which they don't have to do. 62. McClellan finally turned over the Purdue report on October 4 of 2023 at 9:43 p.m. via email, nearly 10 months after he was required to do so under local rules, and was well over a month after Holman had received the report in mid-August of 2023. 63. The Purdue report that the prosecutor finally turned over to the defense further exposed the lack of veracity of Liggett and Holman's August 2023 deposition testimony, which further explained why Holman tried to hide the identity of the Purdue professor and the contents of his 2017 report. 64. In addition to those discovery violations already identified, the state of Indiana has also failed to produce other evidence that the defense has had to either pursue its own or make a specific request from the prosecution. Some of the evidence includes, but is not limited to, the following. A, the faked crime scene image found on Brad Holder's Facebook page. The defense had to travel to Georgia to retrieve a copy of that image. To this day, the state of Indiana has not turned over a copy of said fake crime scene image, while having to admit in deposition testimony that it is real and was found on Brad Holder's Facebook page within weeks of the murders. B, Video of the ritual in Fort Wayne involving Brad Holder and Patrick Westfall, in which Westfall can be seen marking a tree with his hand at a similar height on that tree as the F that was found on the tree at the crime scene. After finding references to that ritualistic video in an email from Detective Greg Ferenczi to Tony Liggett, the defense had to ask for that video, as the prosecution had not yet turned the video over to the defense. The video was finally received on or about September 8th of 2023, around 10 months after the prosecutor was required to turn it over to the defense. C, video of Elvis Fields' interview was not turned over until September 8th of 2023. D, video of Johnny Messer interview was not turned over until September 8th of 2023. E, video of Rod Abrams interview was not turned over until September 8th of 2023. F, video of Ned Smith interview was not turned over until September 8th of 2023. These attempts at concealing evidence at the hands of Holman and the prosecution detailed in this motion provides the underpinnings to support the defense position that law enforcement and the prosecution continue to hide evidence from the defense and do so without care or concern of any consequences from this court. The defense recently filed its it's a big statement, and it's a sad statement. The defense recently filed its motion for early trial for several reasons, including concern for their client's safety and mental and physical health. The biggest concern the defense has concerning the early trial request is that the prosecution's continued violation of the discovery rules. 68, the defense would therefore request the court to compel the state of Indiana and law enforcement to turn over all relevant evidence in its possession. Again, as the defense does not have the luxury of knowing what is in the state's possession, the defense can only specifically request discovery that the defense believes exists based upon common sense understanding of the evidence that they currently have in their possession and the evidence that should exist as an extension of the evidence that the defense has already received, which is going back to your earlier point, how you can sniff out Brady material.
I'm hoping that at some point they say
connecting the dots.
anything that they deem not relevant or not subject to disclosure get turned over to the court for in-camera inspection.
69. The defense is requesting the court to compel the state of Indiana to turn over to the defense by no later than Monday, March 18, 2024, all evidence that it may have in its possession but has failed to turn over, including the following. A, all reports that detail how certain videos that should have been found on a hard drive labeled Delphi DVR_original were purportedly deleted between February 13th and February 20th of 2017, including deleted videotaped interviews of Brad Holder and Patrick Westfall. This would include any reports that detail how the erased videos were discovered, what attempts were made to retrieve the erased videos, and an explanation for how the deleted videos were erased, and any attempts to contact the subjects of the erased interviews for a re-interview. B, all reports that detail how certain audio was missing in certain videos found on a hard drive labeled Delphi DVR_original, in which the video is present, but the audio is not. The defense would further request all reports that detail why there is no audio, what efforts have been made to retrieve the audio, and any attempts at recreating the audio by re-interviewing those seen but not heard on the video. C, the identity of all persons whose interviews were erased as detailed in paragraph 69A above, and also the identity of all persons who are viewed on all video in which there is no audio as detailed in paragraph 69B above. D, similarly, the state of Indiana provided hard drive Delphi DVR drive 1 export in which the state of Indiana claims that, quote, there is no detectable audio on the original drive from which the duplicate was made, end quote. The defense requests the court to compel the state of Indiana to identify all persons viewed on this hard drive in which no audio was available, as well as a synopsis of what was said on the missing audio. E.
Wait, are you telling me that they've got interviews that they can't tell who the people are? They need the state to still identify who the person is. It's like, what? I mean, reports usually say, I interviewed Bob Mata. It was audio taped, and that is evidence number 10. Then you go to evidence number 10. So I don't understand how it can be so disorganized, and it makes zero sense. How in the hell is the state supposed to know if the defense doesn't know? How's the prosecutor supposed to know?
That's a rhetorical question, right?
Sure
E,
is.
on hard drive, Delphi DVR drive 1 exported appears that a sketch artist made with a lady and then sketched out an image of a male. The defense has never seen this sketch, nor has the prosecutor produced the sketch to the defense. The defense requests the name of the female who appears to provide the information that resulted in the sketch, as well as the documents of the sketch artist. In parentheticals, the defense has seen other sketch artists produce in other sketches, and parenthetical, and the substance of the conversation between the sketch artist and the lady providing the information in all law enforcement reports detailing why law enforcement asked this witness to provide information for a sketch artist. Furthermore, the defense requests the court to compel the state of Indiana to produce the sketch itself. F, all of Derek German's law enforcement interviews, including video, audio, and or notes, reports memorializing any law enforcement interview. If he was never interviewed, the defense would ask for confirmation of that fact. For purposes of establishing a timeline, all of Kelsey German's phone dumps of all phones attributable to Kelsey German, if her phone was never collected, the defense would request confirmation of this fact. Furthermore, every law enforcement interview of Kelsey German, including video/audio and or notes and reports memorializing any law enforcement interviews, if she was never in fact interviewed, the defense would ask for confirmation of that fact.
Wait, who's
H,
Kelsey German?
it's Libby's sister.
So,
Uh,
I mean,
these are family members. The next two paragraphs are family members. So that was like just H, all of Cody Patty's phone dumps and all phones attributable to Cody Patty. If his phone was never collected, the defense would request confirmation of this fact. Furthermore, of every law enforcement interview of Cody Patty, including video and audio and or notes/reports memorializing any law enforcement interviews, if he was never interviewed, the defense would ask for confirmation of that fact. I, there are two images that exist, but which the state of Indiana has not turned over to the defense. Those images can be found on the internet, with at least one of those images seemingly adopted by law enforcement as being legitimate, as it has been utilized by law enforcement in various media appearances, including a 2019 press conference. We are talking about the photo of Abby Williams walking on the bridge, purportedly taken at 2:07 p.m. on 2/13/17, attributable to being sent via Snapchat from Liberty German's phone. Also, an image of the High Bridge purportedly taken at 2:05, also attributable to being sent via Snapchat from Liberty German's phone. Related to those items, the defense would ask the court to compel the state of Indiana for the following that so far has not been produced. Roman numeral 1, interviews or reports of Kyle Smith or anyone else that received either or both images taken on the bridge purportedly at 12:05 and 12:07 p.m. Respectively, purportedly from Libby's Snapchat. Roman numeral 2, all reports, analysis, and documentation detailing any information about the images purportedly taken at 2:05 p.m. and 2:07 p.m. and sent out via Snapchat. Roman numeral 3, all reports, documentation, and analysis from Snapchat or any law enforcement agency dealing with the data confirming when those images were taken and where they were taken and how they were distributed, including all reports related to the data and the metadata. Roman numeral 4, any analysis related to those images that has been conducted by any law enforcement agency, parenthetical, or by any person or governmental or private entity that has worked with law enforcement, and parenthetical. 5, if the state of Indiana does not believe that the image of Abby walking on the bridge at 2:07 p.m. and of the bridge taken at 2:05 p.m. are discoverable because the state of Indiana does not claim those images as relevant or reliable, then the defense requests confirmation of the same. J, all reports and or documents, including phone dumps from any phone or electronic device that was believed to possibly be a phone or electronic device of either victim used near the high bridge or in any area that was geofenced near the high bridge and was identified as a victim phone that is different than the phone found at the crime scene. K, all
Wait.
emails between,
It is believed possible by wait, so what is he asking for there?
where
Oh, okay. In J.
all reports or documents, including phone dumps from any phone or electronic device that was believed to be possibly a phone or electronic device of either victim used near the high bridge and or in the area that the geofenced near the high bridge and was identified as a victim phone that is different than the phone found at the crime scene. K, all emails, Professor Turco and any law enforcement officer from 2017 to present. L, all reports, documentation, notes, or analysis of geofencing data related to this case. M, the identity of the person or persons, presumably law enforcement, that labeled the geofencing data, including labeling a second phone as a geofence victim, end quote, that was not the phone belonging to Liberty German. And the identity of, quote, the geofence victim, end quote, from a phone that does not belong to Liberty German. O, the identity of the person or persons, presumably law enforcement, that reduced the geofencing coordinates of multiple phones on February 13th, 2017, between 12:39:54 p.m. and 5:49:23 p.m. to a map tracking the various phones on that date between those times. P, all interviews, reports, documents, or memorialization of interviews of anyone whose phone was found through geofencing in or around the crime scene at the time law enforcement is claiming that the murders took place the afternoon of February 13th, 2017. All Q, all reports of all leak investigations not related to the Mitch Westerman leak investigations, including any reports made by Nick McClelland of content providers reaching out to him, claiming that they were in possession of leaked information, in which McClelland then ordered the content provider to delete the images. 70. Finally, the defense
I mean, I
further
don't think
requests.
that's strange if that's what he's asking them to delete from the
Yeah, I mean,
public. Right. I guess he could have had
look,
them send
man,
it to him so they could figure out the metadata, who it came from, but at the end of
I
the day,
guess,
that's not all that important.
I guess. I mean,
Go ahead,
I
70,
never
do it.
really, I never got into the leak stuff all that much. I don't know how many images were allegedly leaked. I know a bunch of people said they got them.
All right,
I
give us
mean,
70, give us 70.
who can really know? Who can really know who got what? The defense further requests that the state of Indiana can be sanctioned for the variety of discovery violations detailed in this document. Specifically, the defense requests that should any violations result in the need for a continuance of the early trial in order to evaluate late discovered evidence, that the time be applied against the state of Indiana and not Richard Allen. Wherefore, the accused move this court to compel the state of Indiana to provide all relevant evidence in its possession to the defense, including all specific requests made in paragraph 69 herein. Respectfully, Andrew J. Baldwin. All right, so there you go.
Wow, I'm gonna jump in real quick with the question. So would it be
Do it.
smart for the defense, if thrown off again during the next hearing, to have backup defense attorneys that have spoken with Mr. Allen to jump on pro bono and file ready for trial? I would say no, because there's no way in hell any new lawyers can be ready for trial. I mean, you've got to be effective counsel, not just counsel, and they can't just go based off of like, hey, this is what we think. They've got to review everything. They've got to, I mean, somebody should be out there interviewing all of these witnesses and things like that. So, and hopefully it won't be an issue, but, no.
I mean, you're gonna like, yeah.
You can read Candace's question. The answer is no, though.
Where is it? I didn't see it.
It's up there in front of you. Can't you see it?
Oh, sorry. $5 holla. Candace, would you consider a request to practice law in Indiana to represent Mr. Allen on appeal if he's convicted? No, I would not. And there are many, many incredibly capable attorneys in Indiana. and many of which were willing to fight.
Right.
Just trust me on that one. $2 holla, $10. Appreciate you so much. Regarding Holman lying about knowing Turco, and when, along with misleading on the report, can this be amended to the motion to dismiss being heard on Monday?
I mean,
I mean,
in
in
theory,
theory, you know, like, I mean,
I
is
guess
Gull
there.
gonna allow for it? Probably not. You know, I mean, in theory, of course. I mean, like, and that's not new intel. Like, we knew
Yeah,
that
I think
we
he can
knew
raise
Holman
it. He
lied.
can raise additional facts at his hearing. He's not, like, bound by the only factual
Like, you know
allegations
what?
in
I
his
mean,
motion.
you're right. Like, in a real world, in like normal court world, you're correct, but we're just not in that world. You know, like we're nowhere near that world. We're in bizarro world, which you know, it's like I know enough Indiana attorneys, and some of them are goddamn great attorneys that are mortified on the way this trial is being handled. You know,
And, for Atticus, thanks for the $14 there.
$14 holla. Come on, you can't do holla,
Asking
really? You're gonna fight me on the holla
asking
too?
what are no, I'm just, I'm not as animated. Um, it's like if you're not here, I'm like, $14 holler.
It
Holla.
was so cute, though.
Uh,
It was so cute.
what of your personal experiences regarding the turnover of discovery? Is it generally ethical and orderly, or more like gamesmanship? Surely nothing like is occurring in Delphi. So, like in your everyday normal case, like, eh, yeah, I would say that discovery gets turned over ethically and orderly. But when you're dealing with like a case of this magnitude, you always have issues. And even if it's not like necessarily an ethical issue, it's, the police dragging to get it over to the state. And then you never know, right? You never know if what the state's telling you is accurate. But, I've had, multiple issues with discovery, getting things, but I often find, and I've said this before, that we always listen, as should any defense attorney really, but always listen to the recorded interviews, because what the cops write is usually not right. It's just the way that their perception of what the person has said. And so that is often um an issue. And then I know later Bob will come back and definitely um read
Yes,
all of your
100%.
comments and thank you all again, later. I just wanted
Everyone who gave us love,
to pull the
you know,
questions.
I'll always give you shout outs. That's for certain. But I do want to keep reading here. We've got some very compelling
You're gonna
stuff.
go on to the next, is it even the same subject? Oh, wait, I should pull that off.
Yeah, it's
Okay.
great. You're gonna love it. You're gonna love it. I mean,
Mm. I gotta
it's
go
Hennessy.
though.
All right, if you got to bounce, you got to bounce.
Yeah, I'm trying to
Just know,
figure out
just know that I
where
love
I
you.
mm,
I
I
love
love
you
you
very
too.
much.
All
Thank you.
right.
Thank you for taking time to join us.
Yes,
Okay.
bye all.
Oops, wrong one. Wow,
I don't
that's
know
like the
what that
tripping
is.
on acid scream.
Screen and
That does.
yeah, right? It
Ooh.
I mean,
All right, hold on. I gotta switch that out. I selected the wrong one. All right,
and
meant
now I'm
this
like,
one right
can't there we
there.
go.
Boop.
All right, now bye.
Bye. Later, girl. All right. So after Baldwin filed his motion earlier this morning, a very busy David Hennessy, who must have uh burnt the midnight oil late into the evening, pounding out multiple motions, all of which we're going to go through, all of which are substantially shorter than Andy's, and all of which pack quite a punch. So I want to start with this one, which I love. Verified petition for recusal from contempt proceedings. Come now, attorneys Baldwin and Rosie, by counsel, and respectfully petition the court to recuse herself from any contempt proceedings. In support of this petition, counsel states, one, I love this so much. One, on October 8th, 2023, by email, the court made inquiries about and suggestions for law enforcement's investigation of a reported leak of discovery materials subject to a protective order, Exhibit L, Appendix, Volume 1 at 224, State XREL, Rick Allen versus Carroll County Circuit Court, Indiana Supreme Court. Paragraph 2, in that email, the court sua sponte, on its own motion, offered to use its contempt power it did not have under the circumstances to assist the investigation by compelling the cooperation of recalcitrant content creators. 3, the court's initiation and participation in the investigation gives rise to the appearance of a lack of neutrality and independence. 4, the court instructed defense counsel that they were expected to cooperate with the investigation, which they did. This was further involvement in the investigation. 5, the court has received much information from the attorneys and other sources concerning the leak that may or may not be admissible in a contempt proceeding. Recusal is appropriate to avoid the possibility and appearance that the court is considering events outside the evidence and testimony actually presented at a contempt proceeding. 6, without having heard any evidence, without even having reviewed the document sent in an accidentally misdirected email, the court has already expressed its judgment that the misdirection of the email was an egregious error. It is therefore at the least appears the court has prejudged the contempt allegation by the state regarding the misdirected email. 7, more generally, the court previously not only criticized the same defense attorneys for the same conduct now alleged by the state to be contemptuous, it also coerced them into withdrawing their representation of Mr. Allen for that conduct. Again, there is at least the appearance that the court has prejudged the state's contempt allegations. 8, defense counsel will be offering admissible evidence that Gary Baudet, aka Fig Solves, a person who has involved himself in this case on the internet, claimed to have received and disseminated confidential documents, and that his source for the documents was an employee of the court. Specifically Judge Gull's clerk. Protesting too much, Mr. Baudet has now written a fawning letter to the court denying allegations that have not yet been made. Let's read that one again. Protesting too much, Mr. Baudet has now written a fawning letter to the court denying allegations that have not yet been made. That's tasty legal writing right there. Under the circumstances, with the allegations of court involvement that will not go unsubstantiated, the court should not be ruling on the admissibility of defense counsel's evidence regarding Mr. Baudet and his activities, much less assessing what value to give it. Paragraph 9, counsel for the state accessed and, in a filing with the court, even quoted an ex parte. David, right? Counsel for the state accessed and, in a filing with the court, even quoted an ex parte motion filed by defense counsel. Docs Pop has confirmed that the ex parte pleading was correctly filed as confidential. Oopsies. The Carroll County Clerk's Office has confirmed the ex parte pleading was only shared with defense counsel and the court. Whoa. One of the court staff has reportedly one of the court staff has reported that they thought a confidential filing applied only to the public and not counsel for the state. Evidence about access to the ex parte pleading will be presented at any contempt hearing. Because it appears that the state's access to the ex parte pleading was enabled by the court staff, whether due to improper training or through ignorance, the court should not preside over any contempt hearing. 10, the court conducted its own investigation of the leak. and lent itself and its powers to the investigation conducted by others. As a matter of public record, the court at least appears to have prejudged almost all, if not all, of the state's contempt allegations against defense counsel, which she did. I mean, it's her bullet points. Her bullet points are what amounted to, in her world, gross negligence. We all remember that. Nothing's different in this. Like what he filed, it's all the same stuff. There's nothing different. The involvement of the court staff will now also be the subject of any contempt hearing. Under the totality of these circumstances, the court cannot appear to be neutral and detached arbiter of the state's contempt allegations, and accordingly, the court should recuse itself from those contempt proceedings. Wherefore, counsel for defense counsel respectfully prays the court to recuse herself. Respectfully submitted, David R. Hennessy. With love, Dave Hennessy. All right, so there's one. So you guys all get that, right? I don't need to explain that. That one's pretty clear cut. You know, she can't, I mean, obviously I agree. And what Dave has done here is made a record. If an appeal is necessary down the road, I'm sure that Dave, being the bright attorney that he is, realizes that we will soon see an order denying this motion without hearing. I have no doubt. But what was important is that Dave made the record, because he's right about every single thing that he said in there. Like any reasonable person would know. I mean, her entire premise of why she was removing them, based on everything that is being complained of now in that contempt hearing, out clear as day. And it was the entirety of her decision to remove them based on their gross negligence. How can she, in what world can any human being, not Gull, just any of us, you know, if you make a decision, and I'm talking about a major decision, how can you then turn around and say that that decision didn't mean anything? Like, you know, I mean, oh, I don't worry about that. Like, I don't feel like that anymore. I guarantee she feels the exact same way she did when she made that decision. Nothing's changed in her mind. Remember how she was asking Brad Rosie, well, what's changed in 12 days? You know, it'd be nice to be able to ask her, well, what's changed in however many months it's been? Nothing's changed. Everything's the exact same. She shouldn't be sitting on it. All right. Love this motion too. Everything that Hennessy filed today is great. This again was filed today, 4:17 p.m. Motion to stay all ancillary proceedings and get this case to trial. This is what Alice and I were talking about. This shit can wait. Kick it. None of this needs to happen before trial. Nick McClelland should be joining in on this motion. Like, honestly, I'm not saying that as a snarky shithead. Like, Nick McClelland should say, you know what, Your Honor, I'm joining in on this because I need to get to work on the case that matters, which is the trial. That's what I need to be working on, not this bullshit. You think he'll do it? I don't think so. Comes now David Hennessy, counsel for attorneys Baldwin and Rosie, and respectfully moves the court to stay all ancillary proceedings to get this case to trial. In support of this request, counsel states, 1, currently pending is a hearing on March 18, 2024 on the defense motion to dismiss and the state's hope to punish defense counsel. 2, I like that he renamed it like that, because that's what it is. That's the real world name. Forget all the legalese. That's what the motion's called. The state's hope to punish defense counsel. Motion to punish defense counsel. 2, motion to dismiss directly affects the case and the prospect of trial. The state's record to punish the defense counsel does not. True story. 3, the state's request to punish defense counsel includes alleged acts and omissions over a year old. Same shit. The state did nothing about its complaints until the days after the Indiana Supreme Court reinstated defense counsel. True story. 4, the contempt hearing has already required many hours of preparation and will require many more. And the hearing will last at least one day, probably 2. Oh, good to know. Thank you, David. This is just a distraction for everyone from preparation for trial, now 61 days away. It is also a disservice to the families involved. Sure is. 5, since the prosecution delayed as long as it did before seeking any contempt sanctions, clearly time is not of the essence. There is no reason not to prioritize trial over ancillary proceedings or ancillary questions of contempt. Any such issues can be litigated and resolved after trial, no matter the outcome. 6, in short, the court and the attorneys need to go back to the critical issues and stop the diversionary filings. How about that? I mean, both sides, no matter what side you're on, you got to be down with that, right? I mean, that's we got to get to the trial, right? That's where we're all at with this thing, right? We got to get to the trial. It's like this thing on the 18th is a bunch of bullshit. I hate to tell you. Like, I don't know what you all think is going to happen with that thing. Like, if your hope is that they're going to kick Baldwin and Rosie off again, and then what? Another OA is going to get filed by Kara, and then we're going to be back up in this way. Let's get to the trial. It's time. Y'all wanted it moved up from October. Here you go. May 13th. Let's go. Let's go to trial. Cut the bullshit. Let Nick do his job. This isn't his job. This bullshit is a bunch of ancillary crap. It's collateral. It makes no difference. Has no bearing on the underlying trial. Do you understand that? It has zero bearing. Zero. Motion number 3 by Mr. Hennessy. Verified, and they're all like, if you guys haven't seen these, they're short and sweet. Like, Hennessy doesn't mince words, you know. He's been doing this a long time. He's not quite as wordy as Andy is. He gets right to the point. Comes now, attorneys Baldwin and Rosie by counsel are respectfully petition the court to recuse prosecutor McClelland from any contempt proceedings. In support of this petition, counsel states, number 1, on January 29th, 2024, the elected prosecutor of Carroll County filed, quote, a verified information of contemptuous conduct, end quote. 2, of the alleged acts or omissions in that pleading are all of the alleged acts or omissions in that pleading are more than a year old. 3, that pleading was filed the day after attorneys Baldwin and Rosie were reinstated as appointed counsel for the accused. 4, Mr. McClelland made no effort to seek punishment for defense counsel in the intervening 1 year. 5, whether defense counsel were disqualified or not, if Mr. McClelland truly felt that they should be punished for acts and omissions, he would have filed his pleading sooner. 6, the facts and circumstances of the filing, the delay, the timing, and the allegations all indicate a personal vindictive attack on defense counsel or ulterior purpose. That filing also does not comport with the rules, the statutes, and case law regarding contempt proceedings. Remember Osbrook's filing, where he laid out all the law that Judge Gold decided to deny, of course, without hearing. And her reasoning, if you'll recall, was that the motion's already been set. That is circular logic if I've ever seen it in my life. The facts and circumstances of the filing, delay, and the timing. Okay, no, I read that one. 7, the allegations are frivolous and unfounded. Short and sweet, man. 8, McClelland accessed, read, and quoted a defense pleading that was filed ex parte. 9, and put their prospective expert on blast. Somebody who hasn't been retained yet on blast. Mr. McClelland's theory on one of his accusations that the defense counsel should have voluntarily communicated with him and the court an accidentally misdirected email. Yet, he did not voluntarily report that he had accessed an ex parte pleading. What's good for the goose? It's good for the gander. 10. Despite McClelland's protestations of an innocent mistake in a later filing, A, no other attorney of record could access that pleading. B, the CCS clearly stated ex parte, which Mr. McClelland would have seen before opening the document. C, Mr. McClelland is a lawyer with nearly 15 years experience and knew or should have known that ex parte means not to be accessed or shared with opposing counsel. And E, Mr. McClelland, having opened the pleading, would have seen the title, which specified ex parte, but he read it anyway because he quoted a portion deep in the document. The concept of innocent mistakes by attorneys will be a part of the evidence at any contempt hearing. 11, Mr. McClelland had communications with a person that had confidential information, which they publicly disseminated and claimed whose sources and who their sources were, but Mr. McClelland did not report that information or direct anyone to investigate it. Those exchanges will be evidence at any contempt hearing. 12, prior to filing his request for contempt, Mr. McClelland had not received or reviewed all of the results and interviews related to his accusations. That will be part of any evidence. That will be part of the evidence at any contempt hearing. 13, Mr. McClelland was present at unrecorded conferences with the court that impact his allegations and will be a part of the evidence at any contempt hearing. He will be called as a witness to corroborate the testimony of other witnesses. That in and of itself, Mr. McClelland will be called as a witness at any contempt hearing. That's what I'm saying. Like, he needed to double up on that one. He has been so advised, yet has not withdrawn his counsel for the state for any such hearing or designated either of the two other prosecutors on the case to litigate his contempt allegations. Wherefore, counsel prays the court to bar Prosecutor McClelland from participating in any contempt proceedings. All right, again, pretty straightforward. Y'all get that one? Do I need to explain it? I mean, he's got to go, right? I mean, as far as this contempt hearing, can't be the guy. I mean, like the fact in and of itself that he's basically being subpoenaed, or he's going to be called as a witness in order to, it's a two-way street. You know, the things with Bodette, you know, I mean, he's gonna be asking Nick questions about him. He's gonna testify. All right, let's keep moving. Let's see. This is filing number 4 by David R. Hennessy. Objection to change of venue. Comes now counsel for attorneys Baldwin and Rosie and objects to the change of venue from Carroll County to Allen County. In support of his objection, counsel states this case was commenced with the filing of a charging information in the Carroll County Circuit Court. Two, all pleadings in this case have been filed in the Carroll County Circuit Court, including the prosecution's verified information for contemptuous conduct. 3, there's been no motion for change of venue filed by either party. 4, there is no basis provided by statute or case law for a change of venue upon the appointment of a special judge. 5, the Honorable Frances S. Gull was appointed as special judge in the Carroll County Circuit Court for this cause. Her authority in this case is only pursuant to that authority or that appointment. 6, there are no charges pending against Mr. Allen. Oh, sorry, guys, I want to blow that thing up. I was wondering, why is this so hard for me to read? 6, there are no charges pending against Mr. Allen in Allen County. 7, the appointment of a special judge does not transfer a case to the judge's home county. Transfer is only allowed pursuant to Rule 79M IRTP. Additionally, Rule 79N states in pertinent part, all hearings involving in-person testimony by witnesses shall be conducted in the court where the case is pending, unless A, the parties and the judge agree otherwise on the record, or the hearing is not before a jury and the special judge determines that exceptional circumstances exist such that the matter can only be heard in a timely fashion in his or her county. The defense has not agreed, and there are no exceptional circumstances. 8, under the appointment of a special judge, the elected clerk and court staff of the originating county remain. 9, conducting proceedings in Allen County imposes a hardship on attorneys and witnesses. Respectfully, David R. Hennessy. So there you go. I mean, that one's also very self-evident. It's clear, you know. They're saying they're not agreeing to having this hearing in her home turf on the 18th. And it's not supported by statute or any of the Indiana court trial rules that she's doing on her own accord. You know, I think that the issue is the people that I know that have looked on her docket. She's got a rather full docket, but what judges do all the time, you know, when they have trials, remember, when a judge knows they're going to trial, they still have their full docket of cases that they hear on a daily basis. They kick them to another judge. That is not an exceptional circumstance. That is not something that like she's not going to be hearing any of that stuff that day. Like everything she's got on her call, whether it's 10, 15, 20 cases, another judge in that large county is going to hear her cases for her that day. It's not an exceptional circumstance. This thing should be in Carroll County. I agree with Dave. Of course, that'll be denied, but the record is made. Let's go. Let's keep rolling. Okay. Motion for specific findings of fact and conclusions thereon. Defense counsels Andrew Baldwin and Brad Rosie by counsel David R. Hennessy respectfully request this court issue findings of fact and conclusions thereon with respect to the contempt proceeding scheduled for hearing on March 18th of 2024. In support of this motion, defense counsel states the following. 1, that Indiana Trial Rule 52A provides that upon the written request of any party filed with the court prior to the admission of evidence in a case where issues are tried without a jury, that the court shall, quote, shall find the facts specifically and state its conclusions thereon, end quote. Wherefore, defense counsel by counsel respectfully requests that this court issue findings of fact and conclusions thereon regarding the contempt proceeding scheduled for the hearing on March 18th of 2024. Dave's digging into the rules to give her the business. He ain't wrong, though. Like, that'll be the first time on her docket that she's given findings and conclusions on why she came to those findings that aren't completely summary in nature. He ain't wrong. All right. Okay, we read that one. And I think that might 312. I think that might be it. 312. Oh no, today's the 12th. I stand corrected. Oh, we got another list. Ooh. An additional list. Let me make sure. I think I put this one up twice. Yeah, this is the one to get rid of Nick. All right. Okay. List of additional witnesses and exhibits for the contempt hearing. This one's filed the 12th. It looks substantially similar. I don't know if he added to it. I'll read through it again. Comes now. Attorneys Baldwin and Rosie notifies the state and the court that in addition to all witnesses and exhibits previously disclosed, he may call the following witnesses and offer the described exhibits. Witnesses: Stephen Wood, Angela Sadlowski, Julie Melvin, Terry Williams, Courtney Parsons, and Matt Hoffman. And I told you who all those people were, except for Terry, which now I know who she is. Exhibits. 1, communications between Bodette and McClelland, multiple. 2, communications from Bodette about McClelland. 3, Anthony Greeno's YouTube title and crime episode entitled Crime Nation, Delphi Murders, watch and review. 4, Rick Snay on True Crime Investigates. 5, Baldwin email to McClelland regarding Professor Turco report. 6, Baudette's communications with Angela Sedlowski. 7, Baudette's YouTube episode regarding Delphi investigation. 8, Baudette's communications regarding court staff revelations. 9, Baudette's communication regarding disqualification of defense counsel. 10, documentation of the relationship between Baudette, Fortson, and Cohen. 11, Baudette sending defense work product to McClelland. 12, Baudette sending information to McClelland. 13, Baudette identifying source in Delphi investigation. 14, Baudette posting regarding sending information to McClelland. 15, Baudette posting regarding digging dirt on Baldwin. 16, Baudette posting regarding working with law enforcement and prosecution. 17, Baudette email of McClelland asking Baudette to delete everything. 18, Barb McDonald on Court TV with leaked information, investigation information. McClelland email to defense regarding Professor Turco report. I guess I should have been numbered, but we know what you mean, Dave. 19, leaked search, warrant affidavit prior to unsealing. 20, Sergeant Holman communications with Terry Williams and or secret keeper. 20, YouTubers Frank Meister and Sleuth video. YouTube, The Inquisitor, True Crime, claiming leaked communications from Rick Allen. 21, Terry Williams posting about insider information of the crime scene and the investigation. 22, October 2022 or October 22nd, 2022, YouTube video of Baudette discussing his knowledge of a bullet at a crime scene and knowledge that a gun was found at Rick Allen's house when that information was still under seal and a week before unsealed. 23, email exchange between Gull and Attorney Rosie, accidentally misdirected email. 24, Baldwin email to Judge Gull on 10/9/23. 25, list of media dissemination by state actors. 26, Julie Melvin documents. And 26, 27, I think it is, YouTube video entitled A Reckoning in Carroll County. Potential exhibits on or about February 29th, 2024, March 1st, 2024, the defense received an anonymous call from a woman in Texas claiming to have approximately 240 pages of leaked documents and agreed to provide them. The defense has received only a few of those documents, all of which appear to be available to the public. The defense also discovered information from the prof, claiming that he had delivered 2 pounds of documents to the Indiana Attorney General. The defense is continuing to investigate that claim, which may result in additional exhibits. So there you go, kids. That's all of it. That's everything. The case that never sleeps is super busy today. Interesting. Very interesting. So what do y'all think? I mean, I think Allie and I ranted enough through Baldwin's thing. Like, it's outrageous to me. You know, it's just not how cases are tried. You know, it's not how the search for justice, true justice, is supposed to happen. And we really need to get this thing back on track. I loved every one of Hennessy's filings. All of them were on point. There's not one of them that shouldn't be granted. The reality is, I think none of them will be granted. And, you know, but the record's been made. Hennessy's been doing this a long time, and he knows the importance of making a record. No, we don't need that. I'm going to get rid of that. We're done. We're done with docs, I think. We done. So, you know, where I'm at this thing, y'all know where I'm at, you know, and it's like, I'm a defense bar guy, y'all. I'm a criminal defense attorney licensed in 2 states, inactive in Pennsylvania, but licensed there. You know, I've been a defense attorney my entire career. If there's ever been any confusion about who I am or what I stand for, that's on you, because I say it every goddamn live I'm on. And, you know, what I'm about on this case is that Rick Allen and his rights are being flame thrown by everybody on that side of the equation, starting with McClelland and law enforcement, and then sadly seemingly by Gull. You know, I mean, it's just it's one of those things where, you know, I'm hesitant to ever be critical of a judge. You know, I hold their office in very high regard. I always have. I really have. You know, I've been in front of judges for a very long time, and I show them the greatest deference. And what I'm seeing here is my honest opinion. You know, if if I was called to the stand in that hearing, Judge Gull would not like what I was saying. Yeah, I would give my honest opinion on how she has performed on this case, and you know, and it's not a Rick is innocence thing. It's a Rick deserves a fair trial thing. That's what it is. It's like for those of you that confuse those two concepts, unconfuse them. They're two entirely different concepts. The man has constitutional rights. And for those of you that think that the Constitution is some kind of weird document that defense attorneys use for excuses to get their clients out of things, you have no idea about the practice of law or what the U.S. Constitution stands for at all. You should be ashamed of yourself. Honestly, read the document, learn about it, and then talk about it. Come back and talk to me then. So, you know, like, I'm going to be there the 18th. I expect it's going to be an absolute shit show. Hennessy's going to be ready. He's going to be ready. You know, I mean, dude's been kicking ass and taking names for 40 plus years. You know, like, I wouldn't want to go up against him. Just saying, you know, I mean, Nick's going to have his hands full. He's going to get all that he wants. And remember, make no bones about it. Have no confusion about the fact Nick picked this fight. Period. This is the defense picking this fight. They're fighting back. Don't confuse the two. Like, if you think that Baldwin and Rosie, after 50 years of curating a career, are going to allow Nick McClelland to just shit on them without any kind of response, that's ridiculous. It was never going to happen. These two guys are not chumps. They're gonna defend their integrity. They're gonna defend their reputation. They're gonna defend their careers, their families, their names. They're gonna do all of that, and they're gonna do it in spirited fashion, I imagine. You know, so I'm you know, I'm sad that this thing's going, because it really is a waste of time. You know, I'm so worried about the state of this trial that it's sickening to me, really, because I just can't. Like, I've tried to give you guys an idea of the movement of time with respect to a trial and preparing for a trial. And you know, y'all remember being in school, like when you take a test and how time just doesn't move normally. It just, you know, you're up against it, and time just moves quicker. So, you know, instead of turning that from like a period in a, you know, in school of an hour or whatever it was, 50 minutes, and just change it to 62 days, 61 days. It's over in the blink of an eye. It's over in the blink of an eye. And I know I said it at the beginning of the live, but for Nick McClelland, who's trying this case, to not be spending every waking moment of the next 61 days focusing exclusively on the only thing that matters, which is the case against Rick Allen, should have everybody that is on the pro prosecution side ripping your hair out of your skull. Like, and if you don't see that, then you don't understand the system. You don't understand how it works. Like Hennessy nailed it. This whole thing, this whole motion is, I'm trying to punish the defense lawyers. Do it after the case. Who gives a shit? Like, seriously, it doesn't matter anymore. It's nothing new. It's the same thing. You know, like I have to think that his hope is that Gull is going to boot these guys off the case again, which would be absurd. But do I see a world in which it could happen? I guess. I mean, how can I sit here seeing what I've seen for the past year and a half from her and not think that that's a possibility, as absurd as it is? as clear as the court was with respect to, like, they know what the bullet points were. They understand that a hearing wasn't had, but they also understand what they were complaining of, that what would have happened at the hearing. And they said it flat out. It's written. Structural error to remove his client or his attorneys. It's like, period. End of conversation. That's not happening. Like, or it shouldn't. And if it does, it's going back up. It's going directly back up. And who's that on? Who's that going to count against? The time for the speedy. Because you know what? Now there's been a speedy filed. And the sad reality of that fact is that I have a feeling that Andy and Brad felt compelled to file that in anticipation of this hearing, in anticipation that Judge Gull might, in fact, remove them from the case again. And now this time, there's a clock ticking. To me, it was the only move to make strategically. I think it hamstrings her. I think it ties her hands behind her back. I think it really does. I think it takes away some of her leverage in terms of her being able to do what she might otherwise have done, because this thing is going. She set the date. So I mean, look, we've got what, 3 days plus the weekend, 3 business days left. We know it's a case that never sleeps. We know all kinds of shit can happen in the next 3 days. It's one of those things, man, that, it's just, we'll see. I fully anticipate getting a bunch of motions or orders tomorrow denying all of Dave's motions that were filed. But like I said, he made the record, and the record's what matters. All right. Let me try to, I want to get to some questions here. Sorry, I haven't been looking in the chat. I don't know if people are popping off, and frankly, I don't care. But I do want to get the questions. I'm assuming my mods are handling it. It always gets a little heated in here, because I really do. I love when people on the opposite side are here. I'll tell you how I feel. Like I'm not hiding from anybody ever. I say what I mean, and I mean what I say. It's pretty simple. Like, I'm not hiding from anybody ever. I need that clear. Like, you're always welcome on my page. If you act like an asshole, we bounce you. It's that simple. If you could be civil in here and argue your side of it, that's cool, man. I'm good with it. And so are my mods. There's no directive from me barring people that are on the opposite side of this thing. Like, this is exactly what I did for 20 plus years. I argued the opposite side of other people. It's what I love to do. So I'll get to all of our new members and all that good stuff, but let me hit the questions. Not really a question, but a comment. $2 holla, $7. Appreciate you. $7 holla is always delicious. Thanks for keeping it real and not chasing likes and clout. It's not my game. I don't really give a shit. It's fun. It's funny because, a lot of people think that's exactly what I'm doing. I'm like, man, I'm reading the pleadings here, sucker. It's like anybody who doesn't see that those things that were filed yesterday is clout chasing. I don't know what to tell you. It's only one way to look at them. Like, if you think that Judge Gull is going to be sitting there giving those things any credence, you're dreaming. You're just dreaming. It's like that's not how the practice of law operates. Like those, like these guys, if you get put on the stand, good luck up there. You're going to have the lead pipe asking you questions. Should be a good time. Should be fun. Melanie, $5 holla. The modders are my favorite YouTubers. Love you. Appreciate that. And I'm covering Karen Reed trial for sure. Like, that is for sure. That's the difference. Like, people tend to, like, I cover Delphi a lot. I do a lot of other shit. Like this isn't an obsession thing with me. This case requires my attention, so I give it to it. And I am very much on the side of the defense and very much on the side of the Constitution on this particular issue. Other cases, I'm much more objective. Not this one. I'm worried about Rick Allen. I'm worried about his trial. And I've got to be a voice out there, and I'm going to be, and no one's ever going to stop me from doing it. David, if I've read any of these already, I apologize. I told you my girlfriend's dad currently sits on a Trump case. You could bet your ass. You can. I'm assuming that's. You could bet your ass he gets a fair trial. He seriously raised an eyebrow at kicking the defense out. I mean, he knows. He's like, I mean, it was the wrong move. It's like it was the wrong thing to do for her. She had a lot of different options, and Hennessy gave them to her. Dock them, pay. A lot of different things you can do to make attorneys feel it, aside from pulling them off. Okay, Candace, another $10 hollow. Appreciate you. Would it be smart for the defense, if thrown off again during the next hearing, have backup defense attorneys that have spoken to Mr. Allen to jump on pro bono and file, ready for trial? I mean, yeah, it's tough. Remember, David Hennessy's handling this. He may pull in another Indiana lawyer or two. That's yet to be determined. Like I said, there's plenty of lawyers out there in Indiana that are ready, willing, and able, if time allows for it, to jump into the fight, especially with respect to this ancillary hearing on the 18th. But in terms of like them coming in, filing their appearance, it's not going to help them learn the case. You know what I mean? The only way that you can prepare for the case is by going through all the evidence, and that's just, it takes time. It takes time. If she removes Rick Allen's attorneys again, she has completely destroyed, obliterated his right to a speedy trial, which is now filed. That argument no longer exists for the court or for the other side. The man has a speedy demand on file. A trial date has been set. I just think that this move has precluded Gull from removing them. And Gull absolutely should be the only motion, where she should just say, this is right. Like, no matter what my past has been, like, I need to kick these ancillary hearings to the end. Like, whatever the case may be, we need to get this trial moving. Nick needs to be focusing on his case. Baldwin and Rosie need to be focusing on their case, because in the interest of justice, we want attorneys that are prepared. It's mandatory. Attorneys that aren't prepared present sloppy cases. Sloppy cases result in reversals and retrials. It's just facts. We want everybody prepared. We want competent counsel on both sides of this. We just do. So Candace, I don't know if I really answered your question. I mean, it's like it's a Band-Aid on a gaping wound is my overall answer. All right, let's see what else we got. $2 holla, $10 holla regarding Holman lying and knowing Turco went all along with misleading on the report. Can this be amended? Oh, we answered this one. It certainly can be raised. It certainly can be raised. Whether or not she's willing to hear it, because like Alice and I think on our live on Friday, we're trying to figure out how this thing's going to go. I mean, is this going to be a thing where Gull is going to have a powwow in chambers with counsel, and where she's going to ask for offers of proof, especially with respect to, David's, his additional witnesses and exhibits? She may have them come back there and say, well, what, what are you getting at? What are you trying to get at here? And he'll tell her, this is what I'm trying to get at. And, at that point, she may deny him being able to put any of that stuff in, which, I'm sure wouldn't shock Hennessy. I'm sure it would piss him off, but it wouldn't shock him. It's been around too long. He knows. Okay, Atticus, thank you again for that $14 holla. We answered that one. Bob and Ellie, thank you for breaking this down. Y'all are amazing. You're amazing, Jen. Thank you for that $10 holla, and thank you for being a mod. And again, to all my mods, like, I haven't seen whether it's been heated in here. I know Mandy always real shit in. People are getting out of hand. I know my mods are real good about trying to keep it cool in here. And hopefully it is. I mean, the bottom line is if you can't use your words that aren't attacking somebody and name calling, you ain't that guy. Like you're in the wrong spot. You know, like if you want to come at me, you better come with some words other than name calling. Like that's like, and I'm here for it. I've told y'all, any of y'all, if you're going to call me names and act like children, I've got no interest in dealing with you. If you want to debate some legal issues that aren't guessing about what the discovery or the evidence in this case is, I'm here for it. But I don't see many of y'all doing that out there. Everybody likes to try to predict the future and guess what the evidence is. That's not my game. It's never been my game. I've never pulled one of my lives off. My lives speak for themselves. In terms of what I cover, it's all there. It's an open book. And you know, like whatever dude filing, like I had so many people, oh, they named you. I'm like, I don't give a shit. What do I care? Like I'm an attorney. I can do I openly, like everyone knows, if you pay any attention at all, that I was assisting Kara in any way that I could. I was there for the hearing that Gull wouldn't initially have a transcript prepared for. She needed facts about what was going on that day. I was more than happy to assist her in any way that I could. And I'm still here. And as an attorney, I could talk to any attorney I want on any case I want. If there's a gag order, they simply don't talk to me about what the discovery is. We could talk about theories, cases, strategies, all that kind of shit. There's nothing that stops me from talking to attorneys. Do you understand that? Any of you that are suggesting that there's something wrong with me talking to any attorneys that are on this case or that have been helping Brad and Andy and Rick Allen, there's nothing with that. There's nothing stopping me from doing that, or any of the lawyers that have asked for assistance. If I was an Indiana attorney, if I was licensed in Indiana, more likely than not, I'd probably be deep into this thing with all the rest of them. You know, I'd certainly be offering my services. I'm not licensed there, so I'm limited. You know, like I can't do anything with respect to practicing there unless I go in pro hoc vice. And I've already told you, I'm not doing that. Did that on Garcia. It's like when you come in from another state, they hate you more than they already hate you. You know, as defense attorney, there's that level of hate. When you come in from a foreign state and come in, they really hate you. It's like double hate, triple hate. It's like, that's not a fun feeling. So do you feel it as another Jesse Snyder? I mean, it's got that feeling, but it seems even worse and scarier. You know, it's like I feel like it's, again, like I don't know what all the evidence is. I just don't. Like all I've seen is the same that all of us have seen. I've seen the PCA. I've seen what Baldwin and Rosie have put out, you know, in their memos and their pleadings. That's all I know. That's all any of us know. I can't know whether or not they have a strong case or not. When I read through what Andy drafted today, I've got to be honest, it scares the shit out of me for Brad and Andy and Rick. Because everything that I'm reading, the actions of the state actors in this stinks of flat out cover up or / corruption. And like they're trying to railroad this guy. I mean, my God, I hope I'm wrong. But like, I just need a rational explanation as to why they're hiding evidence. Like I said it early in their chat. If you've got a rational explanation as to why, let me know. I'm more than willing to listen. I really am. So thank you for that $2 holla, Ralphie and Harley. Appreciate you. Dr. Vonda, always love you. Thank you so much. $5 hollow. This is an honor of whoever donated my membership today. Oh, that's sweet. I'll get to them. Thank you so much. I'm under a firewall and no one talks. This is in their honor. Appreciate you. Appreciate you. That's Dr. Vonda giving back to you who gave to her. So she let's see. I digress. Hennessy's got this. I'm done worrying. That's right. Dave's in the house. The lead pipe. You know, he's like, what was that great old show with the cop who used to walk around with that stick, Walking Tall? That cop used to walk around with that huge stick and smash stills. That's what Dave reminds me of. Except he's crushing prosecutors. Joanne, footnotes, verdict, factoids. I love you. I love you. I love you. Thank you for that $2 hollow. All right, so we're getting to it. New Wood, $10 hollow. Appreciate you. Thank you so much for that generosity. And thank you for being a member. I appreciate you more than you know. Carly Rooks, member for 2 months. Thank you. Yeah, it's been a long day. Had that long trial stream, and then I'm going on 240 today. So I'm putting the work in, y'all, today. It's been a long one because I did 6 with Jay today. So Christine, $10 holla, super sticker. Appreciate you, girl. Thank you so much. Jen, again, $10 holla. Appreciate you so much. Atticus, again, for that 14 holla. Appreciate you. I'll just show you. I'll flash you guys. $2 holla, $10 holla. Appreciate you. JDB became a new 2 member. Family hug. Love you. Kasha with gifting 5 members. That could be your benefactor. She could be one of them. Thank you, dear. You're amazing. Love you. And you're a mod. So I thank you for all of that as well. Jen, you also, as well as being gracious with your physical cash, you're gracious with your 5 gifted memberships. I appreciate that as well. Thank you so much. I think I went through that one. I think I went through all those. Debbie with the $20 house super sticker. Appreciate you. You're an always giver. I love that. Jen, you've been way too generous. Quit giving me money tonight. No more. No mas. No mas. Thank you so much. I appreciate it. And you're like a mod. Like you're awesome. Thank you so much. Saraz, always giver, and 10 fam hugs. Thank you so much. And I'm sure that the people got those memberships are grateful as well. You're amazing. Thank you so much for always being here. $2 holla. That's $7. Did I give you love? $7 holla. Thanks for keeping it real and not chasing the likes and clout. Yep, I read that one. I want to say it's Michelina Kamel. Michelina Kamel. If I butchered that, I apologize. Hashtag the world is watching. $2 holla. Indeed it is. Indeed it is. Like I keep asking people whether or not they think that she's going to cave and put this thing streaming. Man, I hope so. Like if she streams it, then I'll probably only go in. I'll go in the first week for the first week of trial. I'll rent a spot, stay there, get in line, crack, ask crack every morning, get in the courtroom, watch it, probably stream the second week, maybe go back the third week, obviously be there for closings. I'd like to be there for the defense's case in chief. I want to be there for the whole thing. Like, who am I crapping? I'm going to be there for the whole thing. It's delusional to think that I won't be. Charmaine, OG girl. Whoop, whoop. 5 months. What? OG. Veronica. It's about time. Thank you. Family hug. Veronica is the one who got me over at Delphi Docs, which is, as far as Reddit subs, it's the only one I go to. I don't even mess with my own sub over there. The only place I go is Delphi Docs. Got a lot of bright people over there. A lot of bright people. A lot of attorneys in there. A lot of real smart folks. So I'm a big fan of that. So thank you. I don't know if I ever thank you for that, Veronica. I appreciate you. And so I think that's it. Let me run through because I want to give some love to y'all. Did any of my mods see any questions that were good that weren't starred that I should answer? Because I like if y'all are hanging with me for 245, it's only fair that I try to answer some. And y'all, you just have to know I made the mistake of not slowing down the chat. I can imagine, we've had upwards of 1,200 people in here. This chat's going to be intense. So if any of my mods know of any good questions, or like probably the easiest way to do this, instead of me sitting here like an idiot scrolling through all this chat, which I do, like when we're done, I'll go through it and I'll be checking it out. Like I always like to check out the chat, see who's talking shit, see who's giving support. You know, it's but if you have a question that you'd like answered, like now, post it again, throw it back in there. That way it's easier for me, and it'll be at the bottom of the chat and I'll know. I mean, because like I'm scrolling, like y'all were busy. Y'all were busy in here. Was everybody playing nice tonight? Mods? Was everybody playing nice? Do we have some heat in here? I imagine there was a little bit of heat. Let's see. Yeah, I mean, I'm scrolling like in perpetuity here. Like y'all have been busy in the chat. Y'all chatting. Oh, I lost my mouse. All right. Wow. I love that though. You guys have been talking. Wow. So much talking. So much chatting. All right. Well, wow. Yeah, I mean, this is what a big chat looks like. So you guys are really crushing the game here. Ah, Jolene. Jolene with a $20 holla. Appreciate you. Man, you are so generous. You really are. Like, I mean, just in Jay's and I stream today, giving both of us the love. You're an amazing person. Thank you so much for that generosity. You're unbelievable. I appreciate you. Jenny Pajama Pants. It's an amazing handle. Thank you for that $5 holla. I appreciate you. Carly Rooks, always giver. This reminds me so much of the Star of Rock's murder case from the 60s. They are fighting tooth and nail to get his conviction overturned after 60 years in prison. The railroading is there. I am very, very familiar as being an Illinois guy. I actually live about an hour from Star of Rock. And you're right. You're right. There are some parallels. A lot of parallels, actually. It's a very, very astute comment, Carly. And thank you for that $10 holla. All right. All right. Like I see people like, wait, maybe I'm at the bottom. Okay. Maybe. Oh yeah, 8:47. Shit, I'm running into Steve and Dan's live. Damn it. God damn it. Like I like to try to get you guys over there like in a timely fashion. Okay, good. You guys are doing good here. I see some questions. Okay. Bob, did you hear about all the active cells at the site within 90 meters of the girls? No, I didn't. Did you hear about all the active cells at the site with it? Oh yeah, correct. And I don't know if you were late. I read through Andy's motion, so yeah, he was. Yeah, that was my biggest takeaway. That's shocking to the conscience. Like that. Apparently, there's no report that exists. All right, so Sleuthy has a question that she texted to me. Here's a question. What's the big deal about a prosecutor putting himself in a position to be a witness? Well, who's going to question him? You know, it's an awkward thing to be a witness. Like who's going to question him? He gets one of his other guys to question him. He crafts the questions that they're going to ask him. I mean, it's frowned upon, you know? I mean, it's frowned upon. It's like, for instance, that's why, like, if we're going to interview a witness, for example, we always have a prover with us because I can't testify at court if I'm handling the case, you know. So I'll typically have my my private investigator with us, and they're the prover, and I'll have them get up and testify as to what the witness said if I'm like in a situation where I'm having to impeach them. Yeah, so could he continue to prosecute a case where he's a witness? Yes, he's like this is an ancillary proceeding. It's exactly what David said it was. It's ancillary. It's collateral. It has nothing to do with the underlying case. You guys realize that, right? It's like I like And I never want to be condescending. I forget sometimes that, people don't understand like all the nuances of it. But this case, in terms of what's being, or this motion that's being heard on the 18th, has not a fucking thing to do with the underlying case. Like nothing. I mean, like ultimately there was a leak. We're months and months past that, short of some scumbag, like literally in response to these filings by the defense, leaks all the shit out online. And then that affects Rick Allen's ability to get a fair trial because all that shit's out there. That changes the game. You know what I'm saying? But the fact of the matter is they were able to contain the leak in the sense that people had decency, because only an absolute piece of shit would ever put those things out. Talking about clout grab, like talking about just a disgusting human being. Like I don't even know what kind of person would ever put those things out in public. Like no one that I'd ever want to know, be associated with. Like it's just like the thought of it is repugnant. Like that, it's like, but short of that happening, like none of this matters to the trial. Like that is the limited circumstance in which it could affect Rick's trial, like the underlying trial. And like I have to be honest, like the thought crossed my mind, obviously, because I just said it, that there's some like giant asshole out here that would actually do that just to try to submarine this case. It's like, I hope not. Like, I mean, for the family's sake, I hope not. But I mean, at this point, like, how can we put anything like that thing that happened yesterday with these three dudes writing these letters was like the most bizarre thing that I've seen in my 24 years of practicing law. Like, honestly, I've never seen anything more absurd than that. Like, what, like, oh my God. Like, I was reading them and I'm like, all right. Let's see. I'm going to keep going through here. Hopefully y'all are like, let's see. Who's spent their day and night with Bob? CH. I know you have. Appreciate you. Thank you so much. It's been a long one. Been a long run. I'm surprised my voice is still holding up. Sky Blue, she's not going to have a choice. I believe the under venue will force the camera. Oof, that would, oh my God. Well, what are you talking about? Like, are you talking about for the trial? I don't necessarily care about this hearing on the 18th. Like, I'm talking about the trial. I don't give a shit about this hearing. I mean, I'm going because it's mandatory. Like, I'm going because it's going to be just like a bloodletting, a shit show, like shit being flung all over the place. It's going to be unbelievable. And Hennessy is going to be in the middle of it. Like, to be honest with you, like, I really just want to go to watch Hennessy perform. Like, it's really it's my biggest draw to going, and obviously to be able to tell you guys what happened in there. But that's a big draw for me. Like, the dude's just legendary. It's gonna be like that. That alone is like a huge draw for me. Helen, criminality. Sorry you had to leave your live to go here. But I will go back to wait, did Teresa come over here to check to see if you came over here? Like, if T's on a live, why, like, how's she gonna know? I'll tell her though. So Helen, you're like, I'm gonna tell her because I love Teresa. I'm gonna say that you came over here and you gave her love and you apologized for coming over here, and then you're gonna go back because you love her. So I'll pass that on. Okay. I'll do you that solid. Mata letter to the court coming up next. I don't think so. Not happening. Bob announced early on he's not discontinuing them. What? Discontinuing what? I don't know what it was. Okay, let's see. Delphi Docs is the only sub to go to. Agreed. And they, they get the docs. And I mean, I'll admit, like, they're definitely defense oriented over there. I mean, which is why I love them. They're my people. I'm a defense guy. Like, I'll never forget that. Like, in my core, in my soul, it's like somebody asked me a question during Jay's live today. Could I ever prosecute a case? No, I couldn't. It's not in my DNA. Like, I am a voice for the voiceless. I try to give power to the powerless. I want to protect the principles of the Constitution. That's what I'm about. That's it. Simple. Like I could never do it. I couldn't do it. Okay. Okay, my King of Kings. At this account, I'm not so sure because if RA is found guilty, then he will appeal. And if he's innocent, that means the killer's still out there. Indeed, it does. Indeed, it does. You know, in with respect to the trial, you know, I worry that, you know, I don't want this thing to be done in the sense that it goes to trial. If McClelland's not ready and he doesn't put on a solid case and Rick gets acquitted, that it's never like the one thing. So two things happen there. One, everybody that believes Alan Rick is guilty will continue to believe that. They'll think that he got off. And two, that if he's actually innocent and it comes back with a reasonable doubt type verdict, wherein meaning that the defense isn't able to basically solve the case. You know, I mean, like for an actual innocence case, best case scenario is always for the defense to basically solve the case by saying, this is the guy, or these are the guys that should be in this room right now, not this guy. And then law enforcement then turns around and makes the arrests. And then they try those guys. So where you have that situation wherein this thing goes down and say that he's acquitted and it's a reasonable doubt thing, you know, that everybody's like, man, I kind of like, I think maybe he might have been the guy, but like, I wasn't sure enough to convict him. You know, that is a very unsettling feeling, first and foremost for Rick Allen and his family. First and foremost for the families of Abby and Libby. And then for everybody else, you know, it becomes this thing where, because it was a reasonable doubt type verdict, law enforcement is going to consider that they got the right guy and that he just got off. So what that means is they're not going to pursue any other, even though they say that this is an ongoing investigation. Do any of you get the sense that another arrest is forthcoming? I don't get that sense. And when I read the pleading from Andy today, did any of you walk away from that feeling as if they're doing everything in their power to get everybody that may have been involved charged on this case? I mean, if you're being honest and you're on the prosecution side of this and you're saying, yes, you're full of shit and you're lying to yourself, because it does not feel that way at all. Like, like we cannot ignore every press conference that's taken place. We cannot ignore the fact that, remember, this thing was charged as a felony murder, which again means they only need to prove that Rick was a party to the kidnapping and that as a result of the kidnapping, the girls lost their lives. He's then convicted of the murder. They don't have to prove under that charge. They don't have to prove the murder. Now they've subsequently, he's seeking to add these two, you know, the two just straight up murder counts where he does have to prove each and every element of the murders, you know, but he still has that as a fallback, you know. And I mean, we just know what law enforcement and McClelland have said, that they believe that there's other people involved. Like, and if that's not a huge indication to you that at that point in time when they charged Rick, that they did not have the confidence in the case to charge him with straight up murder. Like, I mean, like every defense attorney that saw that PCA come down and he was charged in that fashion knew immediately that they had a shit murder case on him. I mean, it's always the thing. It's like, it's the easier route for the prosecutors to get their murder conviction. It just is. And it's very unsatisfying to everybody. $20 holler from Cindy Goddard. Appreciate you. I'll have to rewatch and definitely will, because I couldn't leave Criminality. It's because of her I even know about her, your channel. So this is on behalf of her. Appreciate you. And T knows how much I love her. So I got nothing but love. I'm glad you were over there hanging. I'm sure T was knocking out of the park as she always does. She's one of my homies, one of my super homies in this crazy true crime world of YouTube. I don't have a ton of them, but the ones that I love deeply and will love for years and years to come. And she's definitely one of those humans. So thank you very much for that. And I will let her know of your generosity on her behalf. Okay, let's see what else we got. Okay, Scott, I don't know if this is a question. Sleuthy, he talked to a YouTuber during a gag order. So Hennessy said, "You want to go? Let's go, but know that you'll be a witness." Paraphrasing. Yeah, that's exactly what Hennessy said. At the beginning of the live, Bob said that it would be not discussing the letters. Yeah, Bambino, I'm not talking about the letters. And I gave my reasons why. You can go back and rewatch out. Like I laid it out pretty clearly. Not giving them any love on those letters. All right. If RA is found not guilty, then it starts all over again. He's found guilty. He will want a new trial. Either way, it's not over in May. Very true. Very, very true. Lamam. Oh yeah, be there for so Jay and I tomorrow. We anticipate tomorrow's gonna be the last day of the Crumbley trial. Come and peep it. Come and check it out. It's an important case, y'all. It really is. It's like if you're a parent in this country, you might want to check it out. It's one of those cases. It's like it's by far the most important trial that's going on right now. It might not be the sexiest in terms of, kind of like the backstory but like in terms of import, there's no more important case going on right now in this country. I assure you of that. It's going to change the way we live. It's going to change the way that courts and prosecutors and law enforcement treat parents of kids that do horrible shit that result in other children or other people dying. It's changing that. That changed with the verdict with Jennifer, the wife, David Shadd, I think Ari will be found guilty. I mean, he could be. I'm like the way this thing's playing out, and him being found guilty doesn't mean that he is guilty. That's the scary thing about it. Welcome. I always like to see EOA in here. I'll check it out. I haven't watched it. Oh, A Bridge to It is a good movie title, actually. You should have kept that to yourself. Why you putting your intellectual property out there for people to pimp? Why is Gray Hughes so mad at Bob? I don't even really know Gray Hughes, so don't care. Is Gull going to even read Baldwin's filing? I mean, probably. She'll glance at it. She'll check it out. I mean, she should. You hope that she will. I mean, she's been on the bench for a long time. She's a seasoned judge, which is just what makes all of this so much more surprising to me, to be honest with you. It's just like seasoned judges that are confident in what they do, and are solid on the bench. It just surprises me that she's acting this way in this particular trial. It's strange to me. Just can't put my finger on it. Defense lawyers, will you go live Monday after the hearing for all of us who won't be there? Of course. Absolutely. 100%. I'm sure I'll be exhausted because I'll have to get up at the crack of dawn and stand in line for hours, but I'll power through, all whining aside. Yes, I will definitely do that for y'all. So this looks like a new one. Candace, another $5 holla. Appreciate you. Any cases you can recall to watch that a defense attorney crushes an inexperienced prosecutor? I want prep for how this defense will destroy McClelland. I mean, like, to be honest with you, Exhibit A is always going to be OJ. Like Darden and what's her face were overmatched, but that was a who's who of defense attorneys. And like Ito, had no control over that trial at all. It was an absolute shit show. But you know, you had some of the biggest names in the game in that case, and that was a case where prosecution was just overmatched. So that's where I'd start right there. OJ, go check it out. It's all there. You can stream it. I was trying to get Steve on Murder Church to do OJ, but it would take us a year to get through that thing. It's worth it though. That was appointment television. Unsolved, uncovered. What if the prosecution that initiated the leaks to frame the defense? I mean, I've posited that. I said it flat out the other night. I mean, like my theory on that, and I know nothing. Like I have no evidence whatsoever. I'm not sitting around trying to get people to send me shit. It's not my game. Like I let these other dudes do that. That's not what I do. But what I look at is who benefited from the leak. Who benefited from the leak? Was it Rick Allen? No. Was it his defense attorneys? No. Was it Labredo and Scremin? Maybe for a second. They obviously didn't have anything to do with it. It was the guy who had just been told a week earlier that they were ready to go to trial on January 8th. That's who benefited from it. Whether it was serendipitous, I don't know. But I just know he benefited from it. It bought him time. It bought him time. There is no denying that. It bought him time. Even the 5 months. And, you know, which is what surprises me, that he is chosen with his incredibly precious time that he has left, that he's chosen to take this route. Because, again, I'm going to say it at the beginning, or I said it at the beginning, I'm going to say it again now. Dave Hennessy's handling this for Baldwin and Rosie. We have evidence of it today. Andy spent, you know, probably all night drafting what we just went through first today. Like he's working on the underlying case. He's working on his client's case. He's not worrying about this ancillary bullshit that's going down on the 18th. McClelland can't be working on it because he's the only dude that can handle this thing. You know, I don't know what Luttrell knows. You know, and I don't know if, like, I don't even, for all I know, Luttrell's not even in agreement that he should be doing this. Like, I have no idea what those conversations are going. I would hope that Luttrell, who's an experienced prosecutor, be like, Nick, like, what are you doing, dude? Like we need to be working on the case, bro. Like that's like all your attention needs to be there, because in the blink of an eye, we're going to be stepping in and picking a jury, and it's going to be that fast. It's going to be that fast. I'm just telling you from experience. All right, let's see. No, I can't even put anything up about that dude. Yeah, for real. I mean, who doesn't want to go see Hennessy? You know, like it's. I mean, the guy's won 100 murder trials. It's hard to wrap your mind around that. Odd structure. Thank you for being a member, by the way. Consequences for Holman lying under oath. Nothing. You know, like nothing. Technically, it's perjury. Like, what do I think is going to happen? I think nothing will happen to Holman. That's what I think will happen to Holman. Sleuthy, I watched a little bit of the art of deduction and got mad for him saying Bob is an idiot. It's rich. I actually like Sleuthy came on or went on his thing, so I watched like the last hour. It's like I find it really hard to be mad at that guy though, just because he just doesn't understand the system. You know, it's like he's trying now. Really is. He gets so upset. You know, he comes in my DMs, name calling me. I'm like, that's not the way to approach me. Like, you're never gonna get me by insulting me like that. Like, I'm never gonna come on your show or debate you or do anything when you're name calling me. It's like, I'm not a kid. I'm 54 years old, for fuck's sake. I'm a goddamn adult. Like, I don't do that. Like, I don't do that to other people. And when other people do it to me who don't know me from a hole in the ground, you're in no position to ever talk to me like that. Any of you, ever. You don't know me. And I'm hard pressed to think if you'd say it to my face. And you'll always know where I'm at. I'm pretty much an open book. So, you know, let's see what else we got. Bambina, the fact that they don't even have access to half the evidence is mind blowing. I agree. I mean, it's probably more than half, but it's unsettling. It's unsettling. It should have everyone in every area of this case that cares about this case and justice for the girls should have them concerned. If it doesn't, then you're just like I like everything that you say rings hollow. Because it just does. It's like anybody who's so convinced on Alan's guilt that they're blinded to what's going on in this trial is absurd. Like that's like you can't know anything until the trial happens. Like, what do you not get about that? For those of you folks out there that like, and you're allowed to think that he's guilty, but all I'm saying is please wait until trial. Let the evidence get vetted, and then if it can, if it just locks in what you've already believed, then good on you. But like to say anything definitively before a trial has occurred is just ridiculous. It's ridiculous. I mean, like I will go through entire trials where all the evidence is vetted and still not know. Sorry, T. We had you, Bob, and G all at the same time, trying to keep up with all the Grizzlies were going too. Hey, considering I had very, very stiff competition with G and T, I'm awful grateful to all you 1,200 that at the peak that came in here. Thank you very much. I'm heartened by that. It means a lot to me. Thank you very much. It really, really does. Veronica, I haven't seen evidence to know if RA is guilty or not. Right now, with what I know, I would have to say innocent if I'm a juror. Thank you. It's exactly what I was just saying, and that's the right place to be. And if you had said in that statement, with what I've seen right now, I'd have to say guilty. I ain't sweating you because you're allowed to have an opinion on the front end, but you're smart enough to know that you have to wait for trial, that all of us do. That all you have at the beginning of a case and during the entire pretrial are theories. You have a state's theory, as I've told you guys many times. They weren't there when the crime was committed. McClellan wasn't there. Holman wasn't there. Liggett wasn't there. Carter wasn't there. They don't know. They found evidence and they put a theory together, and it took them 5 years. It's like we have to wait until trial. We have to see what the evidence is, all of it. And it's got to be vetted. Vetted meaning it's got to withstand cross-examination and scrutiny. And then, maybe we'll be closer to the truth. That's the hope anyway. That's always the hope at trial, is that we get closer to the truth. But anybody who watches enough trials knows that the truth and justice are very rarely the same thing. It says our girl Shay made me this awesome shirt. It's got this cool little decal on it, and it says it's your favorite time. It's my favorite time, which if you listen to my podcast, which you all should, by the way, Defense Diaries podcast, it's very different than my lives. She made me this. She made me a few t-shirts, and I love her, and I haven't seen her in a while. I hope you're good, Shay, if you can hear me out there. Joanne, adore you. Grandma, I get you, girl. I'm with you. I've been yapping, running my big mouth all day, so I feel you. All right. If RA is actually innocent, what legal recourse does he have to get back what was taken from him and his family? Nothing. He's got no legal recourse. None. It's like when you're thinking about wrongful convictions and cases that get overturned after 20 years, and guys, spent the better part of their lives, the peak of their lives in prison, that were wrongfully convicted. I mean, you'll see them recover, but pretrial detainees who are charged, they don't get shit back. And like I was just saying, like if this thing ends up going, and Allen is found not guilty, and they, the jurors talk after the fact, and we come to find out that it wasn't that they thought that he was actually innocent, but they're like, well, like we just, we kind of felt like it was him, but we just like we weren't comfortable convicting him. Like we are living in a world where Rick Allen literally is going to have to fear for his life. I mean, that's the terrifying reality of that situation. Believe me. No, Bob, I don't think another plea is coming. Plea in what? Allen's never pleading out on this case. It's like every creator I've ever seen say that. I'm like, you cannot read a room at all. Like, there's not a plea happening here. Michelle, nope, they're putting it all Allen. Certainly seems like it. Certainly seems like it. Wild Man's mom. Like to meet that kid of yours. Sounds like a great dude. Thank you so much. No better than you to tell it how it is. It's all I can do, and I call it the way I see it. And I could be dead wrong about shit. That's like my opinions are only that, my opinions. Like I said, I don't speculate on the trial or the facts or innocence or guilt. Like I have my feelings. Like I said, the PCA leans innocent. I know what lawyers who believe that their client is actually innocent. I know what they look like. And it wasn't just Baldwin and Rosie. It was Labredo and presumably Scremin as well. Two sets of attorneys look through the same shit and are publicly saying that they got the wrong guy. I mean, like Elvis Fields admitted to spitting on one of the Abby's head. I don't know. I just feel like I'm in a crazy world. What's up, ATS? Thanks for being here. Appreciate you very, very much. I couldn't believe that I didn't know about your channel, like until like somebody mentioned it. Like I'd seen you as a mod, I think over in Tees, maybe somewhere else too. And then I heard that you had a show, and like I went over there, and it's great. So thank you for being here. I always appreciate other creators hanging with me. So if y'all don't follow ATS News, you should. She good. And she follows all kinds of stuff. And she digs. She's a digger. If you like digging, she's your people. No question about that. Veronica, no, law enforcement has said things to make you assume that there's other out there, but confidence is always lacked when they've spoken. I agree. I just do. Like it doesn't like that one episode or the one interview with Carter, like where the reporter's asking him flat out, like, do you feel confident that you have the right guy? And, and he's like, a judge signed the arrest warrant. Like, you just want law enforcement to be like, yeah, we got the right, like, dude, we got this guy. Like, we got this guy. Like, fear not. We got the dude, 100%. They said that even when RA was arrested, and there were others. So where's the others, right? 100%. I think that's like, is that my Discord making that weird beeping? I can never figure out what that noise is. Sonic 7 and Escape, thank you. You rock for hanging with us. Appreciate you. Let's see. Nick blurts out random shit when he's losing in court. There's other people involved. But he confessed. He does. He's a blurter. And it's like, that's one of the things that I wanted to talk about real quick. In terms of like moves, everyone was giving Baldwin and Rosie a ton of shit because they put out their theory of defense, which when you look at it, like, and I've said this, and I know I repeat this, and I know that many of you have heard me say this multiple times, and I apologize for repeating it again. But again, there's 1,000 people in here. I have to assume that you're all not in here every time, but when you've got a situation where, the PCA comes out, which again is the theory. It's a theory. It's the state's theory of the case. Because as I just said, none of them were there when it actually happened. So it's their theory. So, and we're all very accustomed to that just being what is out there in the public, that the media is reporting on, that the media is digging into. For the years that precede trial, is this the state's theory of the case against the defendant? And that usually goes unchecked. And what was so unusual, why it stunned so many people, is that this particular case, the defense didn't allow for that to happen. They decided to even the scales of justice. They decided to put their theory out there. So now you have two theories. And you're allowed to think that the Odinism theory is complete and utter bullshit. That is your prerogative. You're allowed to think that the Odinism thing has legs. That is your prerogative. You were allowed to think that the PCA against Rick Allen is a giant flaming piece of shit and as weak as water. That's your prerogative. You're allowed to think that that PCA is as strong as you could need ever, that he's there. They saw him on the bridge, like he confessed, which came after the fact, but the other things that happen. So to me, that's a non-starter. Like that's the way it should be in every case. Like if you're going to throw the theories out there, and I realize that, we're talking about the legal process. So a probable cause affidavit is always going to come out because it's attached to a warrant. So that's why we see it, but it should not be frowned upon. It should not be angering people that the defense's theory comes out so that both sides are out there floating. Like that's fair, right? Because you can look at it and hate it or love it, like both sides of it, but they're both out there. That evens the scales of justice. So the other thing that takes place is things like what McClelland does. Like we're in response, Baldwin and Rosie do the same thing. And like I've done it many times in your career. I mean, there is no unringing a bell in terms of people's psyche. It's like when you watch a trial and you're hearing a judge admonish a jury and they're saying everything that you just heard that witness say with respect to whatever they just said is stricken. You're not allowed to consider it. Strike it from your minds. Like you've all, if you watch trials, you've heard it. You've heard the judges do that before. Does anyone in this chat out of the 1,035 people in here believe that that's actually happening with 12 human beings? That thing that they heard is now no longer going to be rattling around in their brain, maybe even subconsciously, but it's there. It exists in their mind. You can't unhear it. You can't unring the bell. There's the old saying, you can take the skunk out of the jury box, but you can't remove the smell. They're all the same concept. It's like out there. So when Nick McClelland at that hearing, and I've seen people say that Rosie said it first, and he didn't. I was there. McClelland definitely brought it up that there were these, and it was in relation to nothing that was happening that day. Nothing. Or like at the most massively tangentially, because at that point, he was saying, look, the confessions are the entire reason that they filed the safekeeping thing. This is like this is them just trying to cover his ass. Now he's crazy. Now he's crazy. Now he's treated like a prisoner of war after he confessed. So, like when Nick got that out there, it got out there. Like otherwise we never would have heard of that. We know that would have been evidence that would have been presented at trial. So like that's a way to slip around the gag. Right. And this, that's a way to get out there and get that out to the people, get it out to the public. Prosecutors do it all the time. It's the oldest trick in the book. And, and you see the same thing from the defense here, so it's like those things happening. And do they influence jury pools? Of course they do. They just do. It's like every individual that lives in Allen County is a potential juror, as long as they're of age, registered to vote, have a driver's license. They're Oh, is T over here? What's up, girl? Girl, you a lot of your people were over here. They say they love you. Helen gave like it was either a $5 or I think it was a $20 holla saying that was on behalf of you because she loved you and she wanted you to know that she was popping over here for a hot minute. So she wanted you to know that. And I told her, I promised I'd tell you that she did that. So she did that on your behalf. So thank you, T, for your generosity and your friendship. I appreciate both. All right, let's see what else we got. All right, so Hunting Evil True Crime investigates, but last much is think of a Mason's cult, only here meth ring and trying to play as Odinism instead of a full cult mindset, multi cases, same group and criminal network found around. I've heard this concept. I've heard this concept, and at this point, I cannot poo-poo it. Look, I just know that meth is an epidemic, especially in rural areas of Illinois, rural everywhere. It's where they cook it. It's where they deal it. It's where they smoke it. It's an issue, and there's a lot of money to be had. I mean, when there's money involved, all bets are off. You know. Okay. Tammy, I'm going to throw this one up. They aren't fully invested in the case. They're either lazy, incompetent, or corrupt, or all three of the above. Not a strong case from the prosecution and law enforcement from the jump. I do not disagree, Tammy. I do not disagree. Sleuthy, I'm waiting for him to be like, but the judge, you said if I did that thing, you'd let me win this bullshit. Like, I'm assuming you're talking about the hearing on the 18th. So that, like, I mean, Nick could be thinking that way for certain, you know. Oh, Helen, thank you. Family hug. Welcome to the fam. Thank you for becoming a new member. We appreciate you. Bob's rant at 2 times speed are intense. Ooh, Sarah, I believe that. I believe that. Like Allie was getting pretty ranty tonight. I like that. I like when she gets fired up. Doesn't always have to be me. We still talking about Frank? Yeah. I mean, it's hard. It's hard being Frank, you know? I mean, I can't be mad at him. It's hard for me to be mad at him, even though he says stupid shit. It's like if you watch my content, I'm obviously not a moron. So it's like, you know, it just doesn't rattle me the way that I think that Frank thinks that it might. Okay, let's see. Boop, boop, boop. Yeah, Gray Hughes, like I don't know much about him, man. I popped in one of his lives one time. You know, I ain't sweating him. Guy thinks he's guilty. It's fine. You know, but he's another one of those guys that makes, you know, the little, you know, maps with like little cutouts of Richard Allen's car and little cutouts of Rick being the bridge guy. He's got the whole case figured out without seeing the evidence. He's not one of those dudes. I mean, whatever, man. Can't stop him. You know, can't stop him. Can't stop him from doing it. Do you guys hear that annoying little noise? I think it's Discord. And I have my DND on. Like, Discord does not give a shit. Discord ignores do not disturbs and keeps like that little blooping. All right. I'm losing people. People are getting bored of my bullshit. So I'm going to call it. It was a good run, y'all. 3.5 hours. I think I did 9 hours, 9.5 hours total today. So thank you guys. First of all, thank you to all my mods who have done double duty as well today. I adore each and every one of you. I'm getting really good at not forgetting to thank you because I love you guys. You guys are amazing and I appreciate you so much. And I know with the nature of some of my lives that you're in the shit in there. So thank you for everything that you do from the bottom of my heart. I could not do it without you. It means the world to me. It really, really does. And to you, all of you guys, to everybody, it looks like I got some more love. I gotta give people the love. Okay, $2 holla. So Helen, I did thank you and gave you our the family hug. I'm so appreciative. $2 holla. Do you think McClellan drops the contempt now? Man, if I was him, I would. 100% would. Like like there's no benefit to him other than he's wasting his time right now on when he should be digging. Like this guy literally has to be spending all week dealing with this bullshit. And then these dudes who think that they're helping him, sending these letters out, are now creating more work that he's now chasing on some bullshit. Like a bunch of dudes that were trying to like be a part of the case and I don't get it. I don't get it. I honestly don't. I just don't get it. I really don't. You know, like the difference between me, like assisting attorneys because I'm an attorney, and somebody trying to inject themselves in the case, or just that aren't attorneys and really have no business doing anything. Like it's just a different thing, man. It just is. It just is. And I'll die on that hill. And you know, you wanna debate me on it? I'm here for it. Give me your side of it. Tell me like what your incentive was. You know, because my incentive is to make sure that this dude gets a fair trial because it ain't looking like that. I mean, it's getting it's nominally better. Let's see. Hey Bobby, send nudes. Okay, babe. Bushiest beaver. I mean, that could be the greatest handle I've ever heard in my entire life, and I've seen some good ones, but bushiest beaver is pretty amazing. Alicia V, $10 holla. Appreciate you. Bushiest beaver follows it up with the $20 holla. Appreciate you, Bushiest beaver. Thank you very, very much. Dawn Burke, always giver. OG, appreciate you. And Gail, and always give a $5 holla. Appreciate you, Gail. Thank you for always being here. All right, y'all. I'm gonna let y'all off the hook. 3:30. We did good. We did good work in here. You guys, I love you all. If you're not following, think about subbing. Like even if you hate me, just sub. Sub if you hate me, just so you get notifications so you can just come in and hate me. Like that's worth it. Like I definitely watch people that I don't like just so I can like talk to myself and be like, what a fucking idiot. Like do that with me. Sub to the channel. And if you do love the content, please sub. Think about becoming a member. I'm so way overdue for members only live. I feel like the biggest piece of shit, and y'all, it's coming. I promise you. I promise you. Like I think you can see like how like I'm busy, you know. It's not like I'm just trying to fuck off and like just ignore y'all. I'm really not. And I'm gonna give you the love. I promise I am. So I really love you guys so much. And share, follow. Like all those things help in the algorithm. It helps grow the show. And remember, it looks like Joe decided to up and like my boy Joe Jackalone started like, I mean, he knew I was coming with the morning drop, and he's got roll call over there. We're going to be battling for y'all. And I love Joe. Like Joe's my boy, but I mean, we're going to be bringing the heat with the morning drop, and that's going to be me and Allie. Like, I don't know if Joe's daily. We're going to be doing it daily. You know, probably like maybe Joe goes a little earlier. Maybe Joe's like, if we're lucky, I'll probably work with Joe and try to like, cause I'm trying to figure out a time that works for everybody around the country, like kind of a happy spot. And I think Joe goes at 8 Eastern, which is 7 my time, which is not when I would be going. I'm thinking like 8 Central, which would be 9, because I want West Coasters to be able to do it. And y'all that watch from the other side of the pond, you know, I mean, y'all are gonna have to do replay shit on that. Or, you know, if you're night owls, maybe you'll get up, hang, or you'll still be up. Oh, Dean, you ain't never lying. I'm not happy about that Josh Jacobs signing either, brother. So fucking Packers, bane of my existence. Oh, thank you. Thank you. I don't know what it is. Like, I don't know what it is. You know, I don't, I'm not trying to help anybody. Like, you know, I got educated. I am what I am. I know what I know. You know, it's like, I'm not trying to be a smarty pants. I have certain knowledge and I impart it on people. And, you know, I do it in a semi entertaining fashion. Like, that's what I bring to the table. You know, it's like, it is what it is. Um, All right. Okay. Like if I keep going, the chat never ends. You guys are unbelievable. Guys just keep going. You're amazing. You're amazing. All right. So I'm going to call it. So again, thank you, y'all. Cause without y'all, I'd just be an old man talking about old cases. Probably talk to you tomorrow. Like, let's be honest. You'll definitely, Jay, tomorrow, me and Jay streaming Crumbley. If you haven't checked out the trial, please do. If you like trials, forget whatever you're watching. Come and watch the end of Crumbley with Jay and I. We're a killer pair. Like, Jay's the comic relief, and I happen to be pretty funny too. Like, you see a little more of my comedic side with Jay. I'm a little more grumpy and crabby over here on this side. So, but check us out. We're going to be going early, 7 Central. No, I take that back. 8 Central, 9 Eastern. We'll be streaming what theoretically could be the last day of the James Crumbley trial. So I love you all. Thank you.